Welcome, everybody, to the February 27, 2018 Board of Commissioners meeting. Please silence your cell phones, pagers, and other electronic communication devices, and agendas are located at the back of the chambers. First part of the meeting is I will lead us into a moment of silence and into the Pledge of Allegiance. Could you all please stand, please? Thank you. Pledge of allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next on the agenda is review and approval of the agenda.
So moved.
Second.
Moved by DeSanto, seconded by Hadcock for approval of the agenda. Any discussion? Hearing none, all in favor indicate by saying aye with a roll call vote.
Buskerud,
Aye.
DeSanto,
Aye.
Farabee,
Yes.
Hadcock,
Aye.
LaCroy.
Aye. Next on the agenda is the second reading and public hearing of ordinance 08-17-02, Pennington County, to amend section 103 definitions, section 205-B17 General Agriculture District, section 212-B-12 Heavy Industrial District, section 507B, the mining permits, and section 511 fees, and add section 320 to the mining operations to the Pennington County zoning ordinance. First reading was approved on commission meeting Tuesday, February 20th of 2018. For many of you, you've been here many times before. Holly, the office commission manager, has a sign-up sheet for speaking. We're going to follow the same rules that we've started in the last three meetings. 3-minute limit on speaking. What I would ask of the audience is to, during that 3 minutes, go through your agenda. If there's a section that is hot that you want to discuss, please inform us, and we'll take your name, and if we have any questions when that section comes up, we can call on you. So keep that in mind, please. We will be doing the 3-minute time limit, but keep in mind that any commissioner can request somebody to come up and get clarification and so forth as we go through this. One of the things I want to review with the commission as I was reviewing some of the broadcast of the meetings, we need to speak into the mics pretty close because there were several times that we couldn't be heard, and I think it's important for when it goes on YouTube and so forth that we can be heard. Also, as we go through this process, during the speaking process, please wait to be identified, and then the chair will ask you if you want to follow up and so forth, so that way we don't get mixing of the comments throughout the meeting. So that's just a request of the chair. I think what we'll do is the same process that we've done in the last two meetings, is we'll go through the pages. This is just for explanation to everybody. I think there's several pages we can take at once, and I'll identify the sections that are improved through those as we do that. And then when we get to specific sections that we want to talk about, and people get called up, we're going to stay in that section for the discussion. So with that, I think we're going to start by taking the public comment, and I'd ask Holly to call the first person up on their list.
First on the list is Gary Mallums, please. And just as a reminder for everyone, when the light turns green, that means your time starts. When it flashes yellow, that means you have 30 seconds. And when it's red, your time is up.
My name's Gary Malums. I'm from the Rockerville area. And you've addressed some of my concerns, but one of them is still, I'm not sure, I wasn't able to attend the Friday meeting, but the one on groundwater monitoring on page 13, I don't know if that's been changed from 1,500 feet, but I requested it be a mile. Because when you get into some of these rural areas, you might not find any wells within 1,500 feet. And I know where we live. I know there's a proposed rock mining operation up there in the Pearly Pit area, and they were going to drill down into the same formation we were in, and they were going to use millions of gallons of water. And when we had the dry season back in, I think it was early 2000s, whenever Bear Country was sprinkling their right of way, our well didn't go dry, but we started pumping water. So we lowered the well down another 60 feet. So I think if we get something in that area, we're looking for problems in a lot of areas because there are several wells, but they're not within the 1,500 feet. So I think that should be changed. I'm not against mining. I know we have some very responsible people that do a very good job. But I think one of the things that needs to be considered, and I'm specifically in reference to the Pearly Pit, if that turns into a bigger operation as they're proposing, we're looking at a situation like the Sturgis Road area. And I know that Pete Lean and Sons have done a great job of trying to screen their operation, but I'd hate to see that happen on Highway 16, which the tourist industry is a $440 million revenue stream for this area. And that's basically my concern. Thank you.
Thank you, Gary.
Mr. Dwayne Abata, please.
Dwayne Abata, I cede my time to attorneys Hickey and Parker.
I didn't hear that.
He conceded his time to Hickey and Parker.
Okay.
Mr. Doug Peterson, please. Or Dave, I'm sorry.
It's Doug.
It's Doug? Oh, I got it right.
Hi, my name's Doug Peterson. I spent 20 years in the mining business, and now I find myself, I live up by Hidden Valley by St. Martin's. I find myself surrounded by mines, 3 of them. And my comments also on page 13, under the setbacks, says no mining operation shall be conducted within 300 feet of any existing dwelling. That's way too close. Mining industries now have the D10s, 992 loaders. These are huge machines. Every one of these machines has a backup alarm in it, which is mandated by MSHA, which are very loud. They're designed to be loud so they can be heard over the mining industry. They're very annoying wouldn't quite describe it. 300 feet is way too close to a dwelling. Should be like 2,000 feet. And that's what I have to say about it. Thanks.
Thanks, Doug. Just to clarify for the commissioners, that's item H, and he's talking under subsection C.
Okay, Mr. Brian Tiedemann, please.
Morning.
Brian.
Brian Tiedemann with Pete Lean and Sons. Thank you for the opportunity to speak. As you all know, Daniel Wiebers and myself have participated and commented many times, so I'm going to keep this very brief. Specifically, we ask today that you consider our comments on Section J, complaints, Section K, revocation, Section I2, transfer of permits, and we are also available to answer any questions regarding how we see the process of Section N, limits of operation, working. Regarding limits of operation, though, that's where my one comment for this point in time is. I think it's important to reiterate what you've heard a few times, is that Pete Lean and Sons is a very good mining member of the community. We're a family-owned business that have been a part of the community for nearly 75 years. We have nearly 200 employees in the Pennington County area alone, so we have a vested interest in ensuring that our current team and our future generations are secure and that they have a viable future. So this is a big picture deal for us, and it's a big picture deal for the people up by the Pearly Pit, and we recognize that, but I think it's important to say that it's even bigger than all of that. The decisions today will impact the entire construction industry in the Pennington County area and all of western South Dakota, and that impacts the taxpayers. And I think that that's something that we have to keep in mind as we go forward. So as such, we've taken this process very seriously, both publicly and internally. And you may have noticed that by the presence of Pete Lean himself and Joel Brannon. They've been at many of our meetings. And as such, they have a definitely a big picture point of view on things. And so as we get into limits of operation, I would just ask that I have the availability maybe to call them up and speak specifically if you have any questions for me or Pete Lean and Sons. So that's all I have.
Thank you, Brian.
Thank you.
Thanks, Brian.
Mr. Quentin Riggins, please.
Thank you. I'm here today for Mr. Smiley on behalf of GCC Dakota. Mr. Smiley sent the commission a letter yesterday, and so I believe that you have his most up-to-date comments. Of import, the statutory construction law in South Dakota is set forth in this particular letter. The plain meaning of this particular statute that's at issue here clearly exempts GCC Dakota from continued permitting and zoning as is being discussed here, which is why we've advocated for the inclusion of the proposed language set forth in the letter. In addition, even if this commission were to find that the plain meaning isn't clear, the next step in the statutory construction would be to consult the legislative history, which is also clear that the purpose of this statute was to enable the continued operation and use of the real estate that was sold by the state of South Dakota to GCC Dakota. As Mr. Smiley said when he last spoke before the commission, the issue here is primarily to ensure that future commissions don't or recognize the existence of this statute, which would avoid things like stop work orders, future litigation, taxpayer expenses, which is precisely why we're advocating for the inclusion of the language that Mr. Smiley sets forth in his letter. As he indicated at the end of the letter, I am available for any questions the commission has relative to this request. Thank you.
Thank you, Quentin.
Mick Harris, please.
My name is Mick Harris. I live east of the Pearly Pit. I'll cede my time to the attorneys Hickey and Park.
To who?
The attorneys.
Mr. Hickey, okay.
Nancy Hilding, please.
Yeah, Nancy Hilding. I did send you some letters, but they got there early this morning, so you may not have read them yet. I'm going to focus first on a thing that is remaining that we dislike very much, which is, what page is that on? Okay, it's on page 2 under purpose. And minimize potential adverse environmental effects through the use of best management practices. I'm an environmentalist. I represent an environmental organization. This is a horrible clause in here. This clause does not improve or protect the environment. It harms or hurts the environment. Why? Best management practices are voluntary. They are not mandatory. So all the way through this ordinance, you shall comply with the state laws, the federal laws, and, you have all of this clause asking people to comply with laws to address environmental issues, but in your purpose, you're destructing that by saying you're going to minimize environmental impacts by complying with best management practices, which are voluntary. So you either need to cross off the entire clause about the environment and go back to the general welfare, or cross off best management practices. Having that in there does not help. It harms substantially your ordinance. I said this before, but you guys didn't hear me. Didn't write that comment down into the comments, and so I'm making it my first comment so you'll pay attention to it. You need to get rid of either the entire clause or best management practices. Okay, so, I suggest being environmentalists, I want you to try to minimize impacts to the environment, but I don't want that best management practices in there. Okay, so another one that we really care about, I wrote this to you in my letter this morning. If we go to page 5, on mining permit process and public notice requirements, public hearing 2, you say, notice of time and place of the hearing shall be published in 3 legally designated newspapers in general circulation in the county once a week for 2 successive weeks prior to the hearing and at least 10 days prior to the hearing. Okay, I calculate that to be 17 days of public notice. So, one newspaper split from the other by a week is 7 days. 10 days, it adds up to 17 days public notice. The people living within 500 feet or a half mile are not the only people who care about this. Thank you for expanding the people who are going to go to letter to a half mile. I appreciate that very much. But a watershed could be affected. They could be further out down there in their water. It could be beyond a half a mile. Their water could be infected. We have air quality. I have a lot more to say, but I never have enough time.
Thank you, Nancy. And the commission has received all your letters and your input.
Mr. Andrew Skull, please.
Good morning, members of the commission. Thanks for being here. First of all, mining is very important to everything that we do. Virtually all products that we either consume come from some sort of mining. Farming, ranching is also a form of mining. We're just mining nitrogen, not necessarily rock. I do feel it's very important to have a fair and balanced approach to mining between stewardship, environmental health, and the necessity to our common way of life. My biggest concern is I feel specifically in the fact that almost at every step of the process, there's potential for a public hearing, creates a lack of clarity and longevity in a potential business plan, especially that of an entrepreneur. I feel that this is a little bit of an overreach, and something that's not being considered is the overall economic impact and the cost of doing business and the cost of infrastructure and infrastructure maintenance as we look forward to our continuing developing community, county, and city, and how that could impact all our citizens. So I think you have come up with a good plan, but I do feel that we have to have a plan that creates consistency and that is not overridden by constant and continuous public hearing at every step, whether it's from new permits, renewals, revocation, and that there is some language that could be changed that could create a better plan for all people involved. Thank you.
Thank you, Andrew.
Is there anybody else that didn't sign up that wants to speak?
Mike Hickey. We sent you a letter that I hope you had an opportunity to review. I think it's important. Last night I reread the Kroll decision, and I don't know if you have read that or very frequently, but I think it's important. We're talking a lot about non-conforming use. The Kroll decision makes it absolutely clear that any mining operation that was located on ag land that generates more than 100 cubic feet based on a construction permit since 2001 is illegal. It's not a non-conforming use, it's illegal. Okay? And I think that you're on new permits, this ordinance does a great job. I think I compliment you on that. I think you've done a very good job of addressing the concerns that the people that I represent have. We do have continued concerns about the existing use, though. And I just think it's important that you recognize, and I've got some particular comments on specific sections, primarily it'd be sections N, I, J, and K, and all those deal with the existing operations. And and again, we're not trying to prevent mining, but we do think there are some reasonable restrictions that need to be placed on existing operations. And I think if you had the chance to read the letter that we sent, there's a California case that talks in detail about the diminishing use doctrine. And I know that you're incorporating that into your zoning ordinance, which I think is fine. But there's language and there's procedures that the California courts have recognized need to be done because of the factual basis upon which the expansion or the continuation of mining operations is going forward. And basically, they have a hearing, and I know that some people don't like hearings, but each one of those situations is unique. It's factually intensive, and you need the information, and you're not getting it under your current language because on your registration, all you're saying is that within 180 days, people have to register. They don't have to supply any kind of baseline information in terms of what their existing operation is. And I think that's a big flaw in what you've got, because you need that information. PJ is going to need that information. The community is going to need that information anytime you come into a situation where somebody says, I've got an existing operation, we're doing extraction, and now I want to move to another part of the permitted area, or I want to move to another even area outside of the permitted area. And so I think you need to look at that very carefully in terms of what information you're getting, what information you're requiring, and put some language in there that if it's not supplied, I think Mr. Farabee indicated, what happens if somebody just doesn't register? Is there any consequences for that? There has to be. Responsible companies like we have in this community, they will do that, but there are going to be some that don't. And you have to have a little bit of teeth in the ordinance to say that it's going to happen. Specifically with respect to a couple of items, we're asking that on renewals or on existing uses that you get additional information. Right now, you're only requiring compliance with Section G of 320. We think you should also include Section F, and I think it's F, C, and D, which is basically a site plan and an operational plan. At least then you've got some objective criteria by which you can judge whether or not the operation is in compliance with the ordinance and whether PJ needs to issue a stop order or not. And so I think that's information that I don't think it's going to be onerous on any committee, any company, because they're going to have an operational plan. They're going to have a site plan just as part of their business plan. And so I think by requiring those kinds of documents, you're going to be further along in terms of answering this really sticky issue on the diminishing doctrine. That, folks, that is a tough issue. That's a difficult issue. And I think that just to gloss over it and say we're going to put it in the ordinance without any kind of detail, I think you're inviting more problems than you're asking for. And again, those operations, they're not a legal conforming use at the present time. They're illegal. And, and that means that we have to address this correctly And if we don't, you're going to create more problems than we have right now. And we have no desire to do that. We have no desire to shut down all mining operations in Pennington County, but there are a few plants out there close to houses that have caused all of this to come about. And you know as well as I do what I'm talking about. And we have to address those concerns because if we don't, and this is not, please don't take this as any kind of threat or anything like that, but what you're doing is clearly legislative. You know, it's clearly referable. And if we don't address these kinds of concerns, I believe that some of the people that I represent are going to try to refer it. And I don't want that to happen because it's not good for us. It's going to be expensive. But you need to look at the concerns that we have and address those. You've done a very good job on the permitting, on the new permits. I compliment you on that. But that existing use thing, we just have to tighten that up a little bit. And I don't think it's going to be onerous on anybody to to require a site plan and an operational plan. I mean, I had conversations with the attorney from Pete Lean yesterday, and we had a very good conversation, and I think she understood kind of where we're coming from, and I think they have concerns on the setback requirements. Personally, I wouldn't care if you could relax the setback requirements and look at it on an individual basis. Maybe the gentleman out there says 2,000 feet is required, and maybe in a particular situation it is. But if it's out in the middle of the country, you know, maybe Pete Lane is right, that you should be able to mine right up to the border of it. I mean, I think that's the kind of flexibility I think that you want to have in this zoning ordinance, rather than it's going to be a flat 300 feet or 2,000 feet or whatever. I think you've got the ability to do that, you know, by giving some discretion in the language of the ordinance. But I have specific comments later that I would ask an opportunity to address you. But with that, I'll just sit down and be quiet because I know you've heard from me way too much. Thank you.
Thank you. Thank you, Mr. Hickey.
Mr. Dean, please.
Good morning, everyone. Thanks for letting me speak again. I don't really have too much more to add,
Can you say who you are?
Jim Dean, Dakota Stone, Hill City. I'm sorry. I'm in the mining business. I'm also in the tourist business. And just one comment, I don't believe that, and I don't know Kroll. I don't have no connection to Kroll whatsoever. But I think what they plan to do up there really doesn't affect tourism really any more than building several great big buildings when you come off of Katrin that block the view to the Black Hills, or any other projects that are going on that, you know, block and cause interference. But anyway, and another thing that I would like to say is that, you know, we appreciate you trying to work with everybody in this matter, and to I know you've been careful to try not to stifle small business in this situation where we have lawyers here fighting for one thing and tribes fighting for another, going after big business. Just appreciate whatever you know, watching out for the small guy also. Thank you.
Thanks, Jim. Do we have anybody else?
Jessica Larson. I am the attorney for Pete Lean and Sons. And after listening to Mr. Hickey talk, I just wanted to clear up a couple of things. I strongly disagree that all of the mining operations are mining illegally pursuant to the Kroll decision. I don't believe that that's what the Kroll decision says. And I also know that in the event the Kroll decision would affect other mining operations, it is well within this board's purview to change the law. It happens all the time. the South Dakota Supreme Court says something and the legislature makes a new law to overturn what they said and to change the law. And this board is well within their rights to do that, to prevent the South Dakota Supreme Court from legislating from the bench and regulating our mines here in Pennington County. That's exactly what you are doing with this ordinance in 320, is you're setting forth what you think is best for the Pennington County residents. And the diminishing assets doctrine was never briefed. That's one of the problems with the Kroll decision. I strongly feel that that was a missed opportunity at the Supreme Court level, and I definitely believe that the Supreme Court would adopt that decision on the diminishing assets doctrine. And so I feel very strongly about allowing mines that have been operating, being good neighbors, employing many residents of Pennington County, and bringing great resources to our community to continue to operate without adding additional burdens upon them. And that's why we really support the limits of operation section as written. I also hate to make threats, but it's very clear that if you take away these mining companies' land and prevent them from mining, and increase the setback areas and prevent them from doing business, there will be lawsuits. And so I know it puts you in a difficult position, whether it's a referendum or a lawsuit, but I believe we go with the mining companies that have been good neighbors, have been operating for 75 years in the community, and I would really urge you to keep those limits of operations and the grandfathering issue as written. Thank you.
Thank you. Thank you, Jessica. Any further comment at this time? We got one more person.
Joel Brannon, Peatline and Sons. I too want to thank the commissioners for all their hard work on this issue. You guys have been working on this for a long time, as well as many other people within the community. And I know there's opposing views in this process, but if you look, and you guys well know, on the limits of operation in section N, the limits of operations, if there's a problem in the limits of operations, it refers you to G. G in this ordinance 320 now comprises of 3.5 pages of additional regulations that gives the planning director as well as the county commissioners the ability to regulate mining. Now, I think mining should be regulated. Everything in this room, almost everything in this room, is either grown or mined. That's what it's constructed from. You further regulate mining to the point that it disallows us to be able to do our job and supply the raw materials. You're going to find yourself, we're going to find ourselves in the same situation as Colorado. The aggregates that go into a mile of highway in Pennington County cost about $70,000. The same mile of highway in Colorado costs about $200,000 because of the additional regulations that the state of Colorado and Larimer County and other counties within Colorado have applied. In California, in San Diego County, the same aggregates that go into a mile of highway cost almost $500,000. Continuing to increase regulations on mining or other industries is going to do nothing but increase the tax burden on our citizens. Now, in Colorado, they have a state income tax. In South Dakota, we don't. Most of the revenue comes from a lot of different things, including property taxes. We have almost 200 employees in Pennington County, and I care about the future of those employees, their kids and their grandkids and my grandkids. If we continue to increase the onerous regulations, you're just going to increase the cost to all of us and to your taxpayers. You've got regulation on top of regulation. I agree with 320. I agree with the limits of operation. I can support that. Have no problem with it. I think we all should have regulations, just like speed limits on highways. There should be regulations for all of us. But the fact of the matter is, making these regulations so onerous that it disallows us to be able to do our job. We've been in this industry for over 70, or in this business for over 75 years, working in this community, supplying aggregates and raw materials to the constituents. And we want to continue to do that, but we have to be able to have some latitude to be able to do long-range planning. Thank you.
Thank you, Joel. Any further discussion? With that, I think we're going to move on. As many of you know, the way we've done this process is we usually go through page by page, but I think as a commission, I think we've worked through, and citizens, I think we've worked through several pages at one time. So I would ask you to look at page 2. There was a change there from our last meeting and some wording, and that come from recommendations from changes from repeated public comment. What had been changed is, what's been added is pozzolan or other materials used into the process of making cement or lime, and some other stuff was scratched out. And as you've noticed from the public comment, Nancy's had made the comment of she didn't like the best management practices in that comment. Then we get into page 3, authority and definitions. Page 4 and 5, you got mining permit process, public notice requirements, and you got a list of stuff there. Under public hearings, Miss Nancy had requested, she wasn't happy with the 10 days. But on the rest of the pages, 6, 7, you have mining permit application, drainage and erosion control permits. On 8, on number 9, page 9, you have general requirements for mining operations. And those go through pages 10, 11, and 12. And so those are the ones I think the commission should take a few minutes to just review those. That would be pages 1 through 12. As I've noted, there was a change on the explanation on section 320 mining operations. So what I'd like to do is have the commission review those. If any one of those sections they'd like to remove, to vote on separately, or to have discussion on, remove one of them sections. And I'll just go through this one more time. Sections of section 320, that would be A, B, C, D, E, which is mining permits, F, mining applications, G, general requirements for mining operations, and that would be at G. So if you'd like something from A, B, C, D, or A through G, hold off and discussed. Or do you have any questions for staff for clarification on anything? Brittany, could you explain, just for Nancy's part, the best management practices for us?
Sure. Brittany Molitor, Environmental Planning Supervisor. Best management practices are typically used in erosion and stormwater type of situations. In most cases, they are voluntary. But in our stormwater regulations, you do have to minimize erosion and sediment control, therefore you have to use them. So in most instances, they're not voluntary. In some sense, it's usually keeping it's a maintenance type of thing. And best management practices also give you some latitude in different types of things that you can use and do. If it works for the situation at hand, there isn't like a specific one that you have to do for certain things. Every business, every entity could use different types of things to mitigate, for mitigation.
Thank you, Brittany.
You're welcome.
So I'll start with Ron. Ron, did you want to pull anything from items A through G on pages 1 through 12?
Well, thought I had one here, but no, I'm fine with it.
Okay. Mr. DeSanto, is there anything on pages 1 through 12, like A through G?
Mr. Chair,
Mr. DeSanto.
I'm just wondering how broad is the scope of the term best management practices? Pretty broad?
Brittany?
It is, for the most part, pretty broad. New technologies always come into play, just consistently new engineering, things like that. And it's kind of just depends on the operation. Some people could use, I don't know, just for an example, like silt fence. Some other people could use wattles. Some people use berms. I mean, they're all a best management practice, but one may be suited in some situations and some may not work in others. So it just kind of gives you some latitude in your ability for mitigation, I guess is.
And if we removed this, what would that do to any type of accountability that we would be able to hold a mining company to? I don't think it would do anything, would it?
Well, I don't know if you could just strike it. I mean, potential adverse environmental impacts through the use of what? I guess you would need some kind of guide, something to put there. I don't know what other, unless Nancy has something that she has an idea for.
Mrs. Hadcock.
Mark, basically, it's a guide.
I understand that.
So it's not something, it gives you diverse or, depending on what's happening on your property, that's what they're trying to say. It's a guide for that. So to take that out, I think, I don't think it's a bad thing. Like I said, it's a guide. It's not a have to.
Okay,
I think.
I understand that.
Did you want to talk?
Well, I would like to hear what Nancy would like to see replace that.
Okay.
I mean, she's talked about it many times,
Yep.
so
So,
I don't want to think she's
Miss
being
Nancy,
ignored.
we have, Mr. DeSanto has a question for you. For clarification.
So Nancy, obviously, we have to put something in there that's going to describe what they're going to be held to as far as a standard. What standard would you suggest that we insert instead of best management practices?
I would suggest that you have this whole ordinance, and you have in there all sorts of remedies for environmental effects. Minimize potential adverse effects through compliance with law, regulation, and the guidance of the commission. When you are restricting this, you're saying you're minimizing potential adverse effects through the use of best management practices, which are not law, they're not rule. You're restricting how you can fix and minimize environmental impacts. You don't want that in there. I mean, and she's wrong. This does not just apply to erosion. I've seen best management practices on sage grouse management. I mean, best management practices can be created for anything. The difference is that they're voluntary.
Thank you, Ms. Nancy. Mr. DeSanto.
And I don't know why you can't just have a goal of minimizing potential adverse environmental effects. Why do you have to qualify that? I mean, your public health, safety, general welfare, why isn't minimizing adverse environmental effects vague enough? I don't know why you have to qualify that.
Thank you, Nancy. I think you got your question answered. Mr. DeSanto.
I have a comment. as well.
Okay, Mr. DeSanto.
I believe that you said it best, Nancy. This phrase, best management practices, doesn't supersede the rest of the ordinance. So it's covered, the way I see it. Whether we've got that wording in there or not, the ordinance supersedes one sentence, best management practices.
Thank you, Mr. DeSanto. Ms. Hadcock, is there anything on pages 1 through 12, A through G, you'd like to discuss or pull separately?
Does he have any more on his besides that
No.
one? Okay, sorry. What is on, operators shall maintain a mining permit from Pennington County to extract, what is pozzolan or pozzolan?
Miss Brittany?
Never heard that before.
When Michelle and I were looking at that, we looked it up and I don't really remember. It's like I think it's like a silica-based type of material, but that was taken directly out of SDCL 45. That's what's in our state statute. That's what's been the comment to use the exact language. So that's what we did. So, and there also should be a comma between sand and gypsum. I think Jerry already added it, but I just wanted to make sure that that wordsmithing was addressed.
Thank you. So, and the purpose, I think, best management practices is good. It's just a guide. It's something where if somebody wants to look up some of their stuff that they need to do or they missed, it's a guide. It's not something that, like Nancy says, they have to do, but it works for people that haven't been in the system or know some of that stuff.
Anything else you think?
Yeah, someone had talked about the 300 feet and some different things. Is that?
Yes, that
Okay.
was item E, number 2.
And
public
water
hearing.
monitoring.
Page 2, that's page 13.
Well, that's
PJ, just a
page
question.
13 on those other ones that you're talking about.
Thank you. Just a question, PJ. Do we have flexibility as a planning commission or a commissioner to change those depending on the issue? Meaning if they're out in ag land, ranchers, well, we don't have to have a permit, but how about the highway department? They don't need 300 feet. They don't need anything. And then the next guy that was up here, he needs 2,000 feet or a half mile. Do we have the flexibility on this ordinance to change that when we're going, following this ordinance if we adopt it?
Anything in the county ordinance can be changed by the Board of Adjustment through a variance.
Okay,
Thank you.
Ms. Hadcock, that's page 13, but that's okay. We're talking up to page 12.
Well,
but-
both of those, I guess it's not a number for me. It's for anything on this ordinance where people are affected in a way that, we would like to change something. We've done it on many conditions on things that we have done through VHRs or anything else. So this is just a guide for us. And if we need to change that based on where you're living or based on complaints, we can change that. So people know that this is a guide and to change everybody's to that would be, we'd be doing the same thing anyway. We'd be changing the conditions. So if it needs to be a mile on the water, it can be a mile. If it needs to be half mile on the notification or meaning setback, I think we could change that. And I know I've done it a lot of times before in any of our ordinances just for health, welfare, and safety of people. So
Thanks, Deb.
thank you.
I will remind the commission, we're on pages 1 through 12, and Deb was talking about item 12, page 12. We're going to get to that after we deal with these ones. But Mr. Farabee, is there anything A through G, sections A through G, that hasn't been discussed already that you'd like to pull off and discuss?
No, thank you, Mr. Chair. Not really, but the phrase "best management practices" always bothered me, and I've been looking for a list of where can I find these best management practices on the bathroom wall someplace, or anyway. Thank you.
Okay, giving everybody the opportunity to speak, I would look for a motion to approve pages 1 through 12, and that is sections A through G, with the changes of just the definition under section 320 mining. That was just some changing in the wording. Those are the only changes on those pages.
I'll make that motion.
Motion was made by Hadcock to approve page 1 through 12 with the changes on, as I noted, A through G.
Second.
Seconded by Buskerud. Any further discussion with the commission? If not, I'd look for all in favor of that. Please indicate by saying aye with a roll call vote.
Mr. Chair, I would suggest that at this point in time, that we ask the public if they have any input on this motion.
Any additional?
I think they already did.
I would ask the chair. I wasn't addressing you.
Okay,
Yes, Chair.
okay. I guess with the way we've set the rules up in the last 2 or 3 meetings is the commission does their work. And I understand that there's some tough issues coming up on this that I think we're going to want public comment on.
Mr. Chair, the reason, the reason for my request is that this is it. Potentially, this is it.
Yeah.
So if 12 pages, if anybody in the public wants to comment, this is it. They should get a chance to comment.
Chairman.
Let me do this. I'm going to go to each. Ron, are you okay with taking, after we make a vote, taking a requesting public input on that vote before we vote?
I disagree with George that this is the final. We are right at the moment, as far as I'm concerned, deciding whether we like those 12 pages or not. Eventually, at the end of all this,
yes,
we're going to get around to making a motion to approve the second reading of this ordinance. And then I think there can be other people discuss it if they want to. But I don't care. If you want to discuss
Okay.
it now, fine.
No, that's good. I wanted to get some feedback. Ms. Hadcock, did you have a comment on it?
Nope, that was my comment.
Okay.
Basically, what Ron just said is we're not making people so they can't speak again. We're just trying to get through these first parts and then having them speak again or ask some questions in between. So we'll never limit public comment based on Mr. Farabee's
Okay.
comments.
Okay. Mr. DeSanto, do you have any comment on it?
I'm just feeling that that it would be easier for public comment as we break this down. So like pages 1 through 12, they can comment on pages 1 through 12. I think that as we break it down, if they come up and comment, it'll be easier for us to remember what they asked about and what they talked about so that we can address it before we vote on the final or the second reading.
Okay.
That's my feeling.
My feeling on this is the last 3 meetings, the way we did this was we took the public comment at the beginning, and then we took some afterwards. And I clearly stated at the beginning of this meeting that we're going to have some tough sections that we have to talk on, and that we will be bringing people up for that discussion. So I think at the end of this meeting, we are going to have a public comment meeting to discuss on that. And so I want to keep things the way they were as we've been doing them for the last 3 meetings, which would be, Mr. Farabee, if you got somebody that you'd like to ask a question to, that's part of what we did in our last 3 meetings on a section. This section here, we've worked pretty continuous on and worked hard on, and there's not much disapproval on this. Our next few pages, we're going to have a lot of discussion on it, and I think we want to get to those before we start doing that.
Well, thank you, Mr. Chair. Then I'd like to ask Mr. Dean if he's got any comments on the first 12 pages. And Mr. Hickey.
Mr. Dean, please come up.
Just quickly.
Okay.
Then after him, Mr. Hickey.
Jim Dean, Dakota Stone, Hill City. The only thing that I would ask is I'm not sure if you guys changed anything on there or not, because somebody mentioned something about a mile. You mentioned something about a mile. Did that get changed? Did it?
That's coming
So
up.
at this point, I'd like you to say, in these pages, nothing has changed and we're moving on, or if you change something, please list to us what you decide you're gonna change so we can
That's what
comment on it later. Thank you.
Mr. Dean, that's what I did.
Okay, you did? I guess I missed it.
It's
So
not,
no changes.
it's not hard. There's the only changes was a little bit under definition, under 320, just a little bit of wording, but the rest of up to page 12 has remained the same.
Okay.
The ones that you're concerned about is page 13.
Okay, well, the whole thing, it wasn't clear to me that you guys had made any changes on the first 12 pages or not.
Yeah.
For some reason, it wasn't clear to me that
Okay.
you didn't. So you did not?
No.
Okay, thank you.
And Mr. Chair, if I'd like to ask Mr. Hickey if he's.
I have no comments on the first 12 pages.
Okay, thank you. With that, I would like to go to the vote as we started under items A through G. And as the only changes, Dean, that were made is definition underneath the first part of operations, just some minor words. Mr. PJ.
Mr. PJ. Yep. Just one quick adjustment, if you would, on page 2 under applicability. The second, what's basically the smaller sentence, reads the mining of sand, gravel, and rock is allowed only in the following zoning districts or future land use designations. Just so it's clear, staff would like to add on with an improved mining permit at the end of that sentence.
With approved mining permit.
So it's allowed only in those zoning districts and future land use designations with an approved mining permit, just to be clear. Sorry for the last minute addition.
Does anybody on the board have a problem with that?
No.
With that, I'd move on to the vote, pages 1 through 12, A through G, sections A through G. All in favor indicate by saying aye with a roll call vote, please.
Buskerud,
Aye.
DeSanto,
Yes.
Farabee,
Yes.
Hadcock,
Aye.
LaCroy.
Aye. Next, that brings us to everybody out there, page 13, section H. Under H is additional requirements for mining operations. Underneath this, we have setbacks and groundwater monitoring on page 13. And then from there, it goes to page 14 with renewals, transfers, and enlargements. I think at this point, we're going to stick with additional requirements of mining operations, sections 1 and 2 on page 13. And it continues on to page 14. But let's concentrate on additional requirements for mining operations 1, 2, and A, B, C, D. As we had some questions on setbacks from Doug Peterson. So we've had some discussion on that from public comment. And on section 2, groundwater monitoring, Gary had mentioned he would like a half-mile change on that. Those were the only 2 requests that I see, and that's underneath H. I guess I would look for some staff reports on setbacks. Or would the board have any questions from anybody in the audience on setbacks? The question was, we've heard 2 public comments a little bit about setbacks, that one thought they were too strict and one thought they were should be flexible to the situation.
Mr. Chair.
Mr. DeSanto.
From my understanding of PJ's explanation, I think that the same would apply to setbacks as to groundwater monitoring distances with the wells. If somebody wants a variance, they can come and ask for a variance.
Okay.
And so it's flexible. Am I correct, PJ?
If I understand what you're saying correctly, I think, though, that if we leave it at 1,500 feet, but someone from the public wants more, I don't know if they'd be applying for a variance on someone else's application to require more. See where I'm going?
Good point.
Chair,
Are you done?
I think.
No, I have a
understand.
follow-up. So that being said, would it be better to increase the distance, knowing that we have some people that would appreciate, and then have the mining operation ask for the variance? And then I'm just trying to feel out what, we've got some people that are concerned about those distances. What's the best way to approach that?
Usually the burden's put on the applicant. I think that's probably the best answer.
So if we increase the distance, then the applicant can come and say, we'd like to reduce that down to 300 feet if they're out in the middle of nowhere and not affecting anyone else, and they have nobody shows up to say, hey, I don't want it that close.
Are you finished? I think Ms. Hadcock's.
I'm finished.
I think Ms. Hadcock's got a follow-up, or
Okay.
not a follow-up, but Ms. Hadcock, did you have something?
So I guess what I was asking, PJ, is we have changed conditions as commissioners without having to do a variance. We have not followed the specifications on a vacation home or anything, house, anything that we've had. We can't change the 300 feet to 1,500 feet or 10 miles if we want, as commissioners when that comes up because of the mining affecting property owners in the vicinity, or same with the water, well water testing.
That's a good legal question. I would ask Michelle on that one.
That's where I was going, Mr. DeSanto, I guess, without having to get a variance. But Michelle, haven't we done that before? Or do we have to stick specifically to what the ordinance says and then they have to get a variance?
And there is some language in here, if you look at some of them, that says at least, so you can go more on some of these, but not necessarily for the 1,500 feet.
Excuse me, Michelle Hoffman, State's Attorney's Office. I believe you would need to comply with whatever the conditions of the ordinance are, and then if the applicant sought something less, they would need to seek a variance.
So could we change it to at least on both of them?
Which would be that, which ones?
Both of them. You said if we put at least in there.
I was just noting
then
that
we could
some of
change
them
it.
give the discretion of at least, that the 1,500 feet requirement is saying within 1,500 feet. If you were to change within on the 1,500 feet to at least 1,500 feet, now you're looking at wells over 1,500 feet out, not within.
Within 1,500 feet. So it'd be, no mining operation shall be conducted within at least 300 feet of existing would work. And then may require the application perform baseline testing up to 3 wells located within at least 1,500 feet of the proposed perimeter. That doesn't change it. But at least if we need to say it needs to be a mile, or it needs to be, maybe the wells need to be less than 1,500 feet as well. So maybe there isn't anybody around for 4 miles, and then we're making them test 3. Does that make sense? So I would put at least in both of those, so it'd be flexibility for a mining company and the public.
Mr. Chair.
Mr. Farabee.
Recommend that we take each one of those on individually.
Take each one of what?
300 feet for, in subparagraph C and the 1,500 feet in 2A. I think we address them separately, and I do have a comment about the 300 feet.
Okay. Right now, Ms. Hadcock, was you
Chairman,
finished?
I'd like to have one of the mining company people come up and see what they think about me changing at least, and what that does to affect their companies, or if it does do anything that's going to adversely affect what we're doing here. And tell me why, too, Miss Danielle, on the 300 feet and the 1,500 feet, what was the theory on the 300 first and then the 1,500?
Sure. When we met in committee, we decided on the 300 feet for the fact that that has to do with the noise and vibration for what we're monitoring out to. So the 300 feet was off of the structures. The 50 feet is twice what any other landowner needs to stay off of their property line. We've proven throughout 75 years of operating, as you've heard, that we can mine right up to the property line. That's the way it's always been. We haven't had issues with that, but we decided 50 feet was a good buffer to keep us back off of the property line moving forward. So that's why we started with 50 feet. If you start making that flexible, I will tell you it creates issues for the mining operators in the beginning of this process when they're doing their mine plan, because it's really hard to do a mine plan where you're saying you don't have any standards. You're just going to wait until you get your permit, and then the county commissioner is going to tell you how far you need to stay off that. So that's why we set those two numbers, the 300 feet off the houses and the 50 feet off of the property line, so we can make sure we handle that. The 1,500 feet, that came from back to the vibration data and everything else too. 300 feet is what we're monitoring for vibration and for blasting to make sure that we're safe. So we've got a standard for that that's a published standard. We went 5 times that to get out to 1,500 feet and said, we'll monitor any wells out to that, because for potential to affect is really probably closer to 300 feet at the most, but we'll take out to 1,500 feet just to cover everyone else. So that's where the numbers came from and why we established strong numbers, so that on the front end, the mining companies could actually develop a plan rather than having to come here and develop a plan one-on-one with the commissioners every time they want to mine something.
Thank you, Daniel. Follow-up?
So Danielle, if you put at least 300, you'd have to start at 300. But if you guys agreed as well, when you came in and there is some landowner or landowners that you decided, okay, we could back off to 1,500 feet, then do you see what I'm saying? It would start at 300, at least 300 feet. And if you guys and the landowners came up to an agreement that said, okay, we are going to be adversely affecting Mr. LaCroix's land, we will go ahead and back off 1,500. It gives you that flexibility to work with the landowner.
I
Or
think
does
it does,
open
but I
it up?
can't imagine a homeowner coming in here and asking for anything less than what they could potentially get. So if I can come in here and ask for you to keep the cell tower outside my front window at 5 miles, and you're going to go ahead and do that rather than sticking to a published number, then I'm going to ask for 5 miles.
Thank you. And then the 1,500 feet, the water monitoring or the 3 wells, again, why did we come up with the 3 wells? You said 1,500 feet. What wells usually,
We wanted to do at least a good sampling of wells around the perimeter of the mine operation, so we could make sure that both the landowners that were adjoining and the mining company had a good feeling that it wasn't just an issue with one well. So we'd like to do 3 wells. We'd like to be around the perimeter, and we'd like them to be as close as possible, because if we're monitoring wells a mile out, but there's wells closer in, that, we're not really sure if we're affecting them or not. So we wanted to do the ones as close as possible so we can see if there's truly an effect from mining. But we left it up to the commissioners to decide what those 3 wells were. So if you've got 100 people that come in here and say, I have wells within 4 miles of the property, you guys can actually look at it and probably go back to the planning commission and ask them, because I know you've got some good technical people on the planning commission that could tell you, these are the 3 wells that are most susceptible to any issues if there are some there.
and I do recall that on the planning commission, we did discuss that, and we did have some engineers, and they understood that as well. So I appreciate that thought, and you coming up here, Danielle.
Yep.
Thank you,
Mr. Chair.
Mr.
Thank you,
DeSanto.
Daniel. I think the concern of the gentleman was that if there aren't 3 wells within 1,500 feet of the mining operation, then how do we know whether or not we're affecting the groundwater? I understand your point that the proximity, you want it closer to your mining operation so that obviously if the water closer to your mining operation is being affected, then you could go further out knowing that and find out how far out it reached too. But if there are no wells to test within 1,500 feet, then what do you do?
I think you could actually just put a clause in there that gives preference to wells within the first 1,500 feet. rather than saying it has to be within 1,500 feet. If it's true you don't have a well for more than 5 miles out, you, as the commissioners, also have the right to say, we're not going to test that because we honestly don't think that that's going to be affected. So we're going to test the ones close to you within a mile or whatever number you guys choose during that particular meeting. That's less of an issue than the numbers up above, because that we can work with after we get the permit. The numbers up above we need set in stone so we can develop our application to actually go on mine.
This is just throwing something out. What if we were to put the language in there to address the concern that if there are no wells within 1,500 feet for you to test, that you test the nearest well? Would that be an issue?
I think that's fair. I think it's fair, and I think it's still in the spirit of what we proposed as far as making sure that we're protecting the community.
Anybody okay with that? Because that covers Mr. Peterson's concern.
Please word that motion. Or maybe Danielle can help you with that.
Yeah, Danielle.
Wow. Let's see, how did
Hate
we
to
have
put
it
you
in
on the
there?
spot, Danielle.
That's all right. I'm good with it. Within 1,500 feet.
If there are no wells within 1,500 feet, we will test the nearest well
Yeah,
to our mining
I
operation.
think that if there are no wells within 1,500 feet, the perimeter will be expanded to the nearest well.
Perfect. I'll make that motion to change that
Is that 3 wells or
to that language.
1 well?
Well, let's try to put this all together. I think Georgie, are you okay now with all the explanation on C, or you still got discussion on item C?
Haven't had a chance yet.
Well, I'm asking you
And I'd like
let's
to-
hold off on that motion if we could, and then if there's no other changes,
Gotcha.
to try and make it neat all at once. Mr. Farabee.
I'd like to split the two. And my motion on H1C,
We need your mic down too also.
on H1C, I'd like to change it to 1,500 feet and add S on the homeowners, and then add on or variance from the Pennington County Board of Adjustment.
Okay. I think you made a good point. Maybe we should have split these up.
1,500
I
feet.
didn't know where you were at on this. So right now, we're going to discuss. We're going to put yours off, Mr. DeSanto, to the next. Under H, setbacks, item C, Mr. Farabee has made a motion to change it to 1,500 feet on item C. What was the other part?
And add an S on the homeowner, so it's homeowners, and then add on and or variance from the Pennington County Board of Adjustment.
Chairman?
Hold on. There's a motion on the floor. Is there a second?
Second for discussion.
Second for discussion. Now, Ms. Hadcock.
Is there original motion yet?
No, we put that off.
I put that on hold.
Okay, so I'll make it substitute for no change on item C.
So there's a substitute motion made by Hadcock under H, item C, to keep it as is. Is there a second? Motion dies for lack of second, so we're on to, back to the original motion. Ronnie, are you following us?
I'm ready to vote.
Okay. So there is a motion on the floor underneath item H to approve all the items. And underneath C, George had made a motion to change that from 300 feet to 1,500 feet and an S to homeowners. And then he wanted to add permission needs to be obtained from the Board of Variance.
The Pennington County Board of Adjustment.
Pennington County Board of Adjustments. Any discussion?
Chairman,
Mrs. Hadcock.
Doesn't it say unless written permission has obtained from the homeowner? What does that mean at the bottom? Shall be connected with an existing dwelling unless at the time or operate unless written.
Any, okay, my only, are you done, Ms. Hadcock?
No, the 1,500 feet, I think the minimum should be 300, and then if there's complaints, it should be increased, and then it can.
Okay.
I see your, geez, oh Pete,
Okay.
micromanage.
Okay, my comment on the current motion on the floor is I'm not in agreement with it. I think we're okay with the 300. I think they've done a good explanation of that. That's just my comment.
Chairman?
Any further comment from the commission? Ms. Hadcock?
I like to protect the people, but I'm going to have to agree now with some of this is government overreach. To the point where I like to protection of the people too, but we always talk about government overreach over here, and then the first person that does the government overreach is the guy that complains the most. So,
Okay. Let's
Pete,
move.
guys.
Let's stick with the issue here.
Yeah, let's stick with
So
overreach.
the motion on the floor is to, as I stated, item C. We're going to take a vote. All in favor indicate by saying aye with a roll call vote.
Buskerud,
Aye.
DeSanto,
Aye.
Farabee,
Yes.
Hadcock,
No.
LaCroy.
No. Motion fails 3-2. So, or passes 3-2, sorry. So the wording on C has been changed to 1,500 feet. Ms. Danielle?
I would just repeat that the 300 feet was science-based. The 1,500 feet, as I've heard it up here today, has absolutely no basis whatsoever other than it's a good round number. So I would ask that 300 feet be used until and if there's a complaint, at which time the board can come back and adjust it.
Mr.
There's
Chair,
no solid
she's out of
reasoning.
order.
No, she isn't. I asked her to speak.
We voted. We voted.
So I asked her to speak, so she's not out of order. No different from what you've done. So, okay.
That's where I'd leave it.
Thanks, Danielle. Next, we've come to item number 2, under additional requirements for mining operations. And Mr. DeSanto had made a change. Could you repeat?
But I hadn't commented yet, so before.
You haven't been acknowledged yet.
No, just, okay, hold on here. I've asked Mr. DeSanto a question.
That's what you told me, wasn't it?
Thank you, Lloyd.
Mr. DeSanto.
How's it feel?
My rewording would say, may require the applicant to perform baseline testing of up to 3 wells located within 1,500 feet of the proposed perimeter of the mining extraction area, unless no wells are present within that 1,500 feet. Then the applicant would test the nearest well.
Does everybody care? Are you clear on that?
Yeah.
Okay.
Second.
Motion was made and seconded. Discussion.
No, Mr. Chair, the other the 3 had a chance to comment before we made a motion. So I'll make my comments now, but I'd like to have Mr. Mellons or anybody out there knows how far the Bear Country well is from your well. Does anybody know that distance?
You need to come up to the mic, sir.
But does anybody that lives out in that neighborhood know how far the Bear Country well is, straight line distance to your well, or wells? They're about a half a mile. Gary Malum's.
Gary.
And my concern goes clear back to when they were granted a permission to put that gravel pit in Crowes, and they were going to drill down into the Deadwood Formation, and they were going to use millions of gallons of water. Our well is in the Deadwood Formation, and the Deadwood Formation also is in Bear Country. So when they sprinklered their right-of-way on the highway, my well the next day pumped air. So if we put a ready-mix plant in the crawl pit, and they requested millions of gallons of water, and they were going to drill into the same formation. So that, my well to crawl pit is probably 3/4 of a mile. And within my radius of where we've got probably 4 or 5 wells. Some of them are in the Madison, but I know the fire department, Rockerville Fire Department, just drilled into the Deadwood Formation. And so my concern is if that would go through and they drill that well, because they've already got the permit to drill it from the state, then we've got a water problem. And what my concern is, I don't want to have to come back down here and say, hey, I got a problem, and ask for variance. I want that to be monitored right up front, not an
I think
afterthought.
the changes were put in there, so, thank you.
And I think what he proposed is acceptable.
On the second part? Okay. Mrs. Michelle Hoffman, please.
Michelle Hoffman, State's Attorney's Office. I just thought perhaps we'd clean up the language a little bit on the motion where it would state if there are no existing wells within 1,500 feet, baseline testing may be required of the nearest located wells.
I think that's how you worded it, wasn't it?
Similar to that.
Yeah. Okay. We're on part 2 of H.
Mr. Hickey wants to speak.
Oh, Mr. Hickey.
I'm sorry.
And you're going to talk on the groundwater, okay.
I'll just clear up some facts, okay? This comes from the water application before the South Dakota Department of Water and Natural Resources. The Gary's well, according to this report, is 3/4 of a mile west of the well site proposed by Kroll's permit. And then the Bear Country well is 1,742 feet west of the well from the Kroll. So that kind of gives you the distances, at least according to the state, at the time that the Kroll application was permitted.
Okay. Thank you, Mr. Hickey. So with the motion on the floor, Mr. Farabee.
To finish my comments,
You didn't, I gave you opportunity.
the reason I was asking about the distance, so obviously there's no 100% scientific proof, but you did experience a problem with bear country. And you're 16, 1,700, 1,800 feet straight line.
Okay.
Thank you.
Thank you. So the
I'm done.
motion on the floor is for under item H, number 2, with the wording that Mr. DeSanto stated and Michelle agreed on. All in favor indicate by saying aye and a roll call vote.
Buskerud?
Aye.
DeSanto?
Aye.
Farabee?
Yes.
Hadcock?
Aye.
LaCroy?
Aye. So that takes us up to page 14, under renewals, transfers, and enlargements, item I. Oh, PJ.
I'm sorry, would it be possible to go back to H1C, the previous motion? Just a comment from staff. Variances are allowed to anything in the ordinance. This is the only part in this specific ordinance where it's stating you need a variance. Could it then be applied that you cannot obtain variances to anything else? So we would like to strike the variance language from that previous motion if you could reconsider it.
That'd be the three that.
So we need a motion to reconsider item H, part C.
We just believe that that language isn't needed. You still have the opportunity anyway.
I would make a motion to reconsider based on, or for discussion.
Motion's been made by Mr. DeSanto.
Can I second it?
I think,
You can reconsider and I can second, can I?
yeah, he was the prevailing.
Okay.
So he's considered, seconded by Hadcock to reconsider item H through C. All in favor indicate by saying aye and roll call vote.
Buskerud?
Aye.
DeSanto?
Aye.
Farabee?
No.
Hadcock?
Aye.
LaCroy?
Aye. Okay.
Nothing
Please
further.
reword that for me one more time.
Basically, just where the S was added on homeowners, put a period and strike the rest.
Motion maker, we don't have a motion.
Nope.
So it's back, it's being reconsidered again. So,
Mr. Chair,
Mr. DeSanto.
I would tend to agree with PJ that they already need a variance, so why do we need to put the language in there? And it could just confuse other sections of the ordinance.
So is that your motion?
I'm not making a motion yet. I want discussion.
Any discussion? Ron, you have any discussion on this?
Need a second.
I didn't make a motion.
You didn't make a motion.
Oh.
It's just discussion on what PJ said about it's already in there by variance.
I'll make a motion then to approve deleting that language, the variance language.
Okay. I still need clarification. Please read that to me, PJ.
Sure. So H1C, the part that was added on the end of C, in red on the screen, underline where the S was added at the end of homeowner. Basically put a period after that S and delete the rest in red. That's underlined.
Okay, so that's the motion on the floor, delete the rest after homeowners.
Second.
And seconded by DeSanto. Any further discussion? Mr. Farabee?
And I disagree, and the reason being, because of the significance of this issue. Now it's there in black and white for everybody to see, those that are opposed and those that are for a variance. It's right there. There's no question. They don't have to go through 200 and some pages of this book. It's right there in black and white, and this is a significant issue. What does it matter to emphasize the fact that there is a way out? Thank you.
Thank you, Mr. Farabee. Any further discussion?
Chairman,
Mrs. Hadcock?
I still believe you can put at least within 300 feet and get the same thing instead of making it 1,500 with a variance. So you can get where you're going in the first place board instead of putting 15 if you put at least in there. That way, you don't have to come in as highway department or anybody else with that 1,500 feet being, 1,500 feet is, Brian Tiedemann, can I ask you to come up, please?
Half a mile.
Yeah, at least. And then if they didn't need it,
Requested from
you see what I'm saying?
Brian. Ms. Hadcock has a question for you.
So, Brian, tell me something. On the tell me why not 1,500 feet, but would the word at least bring it so it would be, I guess it seems more plausible to put at least, because there isn't too many. When we did the half mile, we had, it was me, Brittany, and Holly, and Michelle, and we put that half mile around Peatline. Everything else was heavy industrial, except for a couple spots where it would be need to be at least more than 300 feet. So do you see what I'm saying? So everything else in the county wasn't really plausible in that. So you don't have that many big mining companies. So bottom line is at least 300 feet would make it so that those two areas, we could increase it for those people instead of making it 1,500 feet for the whole freaking mining operation, which doesn't make sense. Does that make sense to you?
Okay, are you done?
Yes, sir.
Okay, Mr. DeSanto.
I said freaking, sorry. Bad word.
Would that, if we changed it to at least and struck the 1,500, would that leave it up to the mine to make the decision? Or would it leave it up to the Board of Commissioners to make the decision if a resident came forward and said, this is too close to my house?
That would be a question that I think an attorney would have to answer to dissect that. But I will just kind of clarify what 1,500 feet would do. Let's say you have a section of land, 640 acres, it's 5,280 feet square, and you take away 1,500 feet from that. If there's a house on either side, you're down to 2,000 feet in the middle of that section. You've taken 3,000 feet away from a property owner and told them they can no longer use that property for its intended use. That's a lot of land to take away from somebody and a lot of minerals underneath that land that are being just completely wiped off the plan. Let's say that it's let's say it's a quarter section. Now you've got 2,500 feet or so, plus or minus or plus, and you take away 1,500 feet. Now you've limited that quarter section down to just 1,000 feet, and that's if there's only a house on one side. If there's a house on the other, the property's done. You can no longer use that property. So
That's an excellent point.
So the 300 feet, like Danielle said, was just determined based on our blasting section within here, which you've already approved. We can blast a lot closer than that safely based on these regulations, but 300 feet was a good concession to say, okay, let's move out that far and follow these regulations, and we'll be able to ensure that we're going to keep everybody safe.
Okay, so the motion, item's been just a minute, been reconsidered. The comments that we heard, that 300 is fair,
At least 300.
is part of it, and we've taken, excuse me, I got it. Now it's been, motion on the floor is to remove, put a period at the end of homeowners and scratch the rest. Is there any substitute motions or any further discussion?
So my motion would be to take it back to the mining operator shall at least have 300 feet of existing dwelling. And then I'd like an explanation from Michelle if at least gives us the opportunity to change that if they're landowners. Like I said, when we did that perimeter and we did that half mile when Buskard wanted to change some of the other stuff, we only seen a couple areas where on the, I'm going to say Pete Lean area that it
Okay.
affect homeowners. So
You started
would at
out with the
least,
motion.
sorry, sorry. So would at least, I should make the motion till I verify. Sorry, Lloyd.
There you go, you got,
Sorry,
you're gonna
sir.
hold off on your motion then?
Yeah,
Okay.
and then tell me if at least would work if we wanted to change it to 1,500 or 2 miles or where we want to change as a Board of Commissioner. Would it give us that opportunity or that flexibility?
So now could you please clarify the question again for Michelle? Did you catch that?
I
got it.
Yes.
Okay.
She's looking like
Michelle
she's-
Hoffman, State's Attorney's Office. I would draw the board's attention to the paragraph under item 1. It's the second sentence. It states, "These are minimum setback requirements, and greater setbacks may be required for mining operations necessary to protect the integrity of slope perimeters from erosion." That's very specific. You could simply say these are minimum setbacks and greater setbacks may be required by the Board of Commissioners. And then if you did the at least 300 feet, at least 100, at least 50, I believe by making that modification gives you some discretion. So if there's a mining company such as Pete Lean and the at least 300 feet is not an issue, then they've met their requirement. If the board, when they review the mining application, feels 300 feet is insufficient, they could in fact increase that setback requirement at the time they hear an individual application.
So Chairman, follow up. So what's the change?
It would simply say, these are minimum setback requirements and greater setback requirements may be required for mining operations, period, or something, greater setbacks may be required by the Board of Commissioners. That might be better.
And that's under setbacks, correct?
Under 1?
Yeah,
Okay.
paragraph 1.
The overarching paragraph that governs A, B, and C. So it's simply, these are minimum setback requirements and greater setback requirements may be required by the Board of Commissioners, period.
Okay, go.
And then subsection C, you would just say at least 300 feet.
At least 300.
Consistent with A and B.
So those would be my motion.
Mr. Chair, I have a point of order.
Not just,
I have a point of order.
no, that,
Point of order takes precedence,
Yeah,
okay?
it does.
okay.
The point of order is that all that we voted on this already, the reconsideration motion was only to delete the variance part. The rest of it's intact. The only thing that the motion to reconsider was the variance. So let's stick to the motion to reconsider.
The whole item was under the reconsideration when it's,
And changes, yep.
am I correct? Now, just a minute here, let me sort through this before you start going on. Michelle, we made the motion to reconsider it, which brings it up as a fresh item, I believe.
Yes, even though the stated reason for the reconsideration was the variance language, the motion is still to reconsider this agenda item.
Only the variance part. I'm sorry. That's what we voted on, was the variance part.
Mr. Chair.
Mr. DeSanto.
Just to settle the waters, if that's how it's needs to be voted on, that's fine, because I'm going to ask for reconsideration for the other anyway. I'm, after what Mr. Tiedemann said, I can't reasonably request that a mining company give up a quarter section of their land and not be able to operate on it because of the setbacks. That's too restrictive.
Okay.
So if we're going to vote on, if we have to vote on it separately, that's fine by me. We can vote on it separately.
Can we change amend the reconsideration? Michelle, is it legal to amend the reconsideration to not just the variance? Based on Mr. DeSanto making that motion?
Well, you can go ahead and just vote on the removal of the variance language and then bring a motion to reconsider the setback requirements.
I guess, here's the deal, guys.
I want you to rule on
No,
my point.
just wait a minute here. I'm talking.
You rule on
Okay,
my point of
no,
order.
just wait. When the motion was made to reconsider, it was to bring back item C. It was not specific on just the variance. It was to rehear item C. I made that comment. Am I wrong?
I have down that it was to reconsider item H1C by taking out the words,
By taking out,
to take out the rest of the sentence after the words
okay,
homeowner.
that helps me. So that's clarification. So you're right, Mr. Fairby, I stand corrected.
Thank you. Thank you.
Let's take a vote on removing the red section only, and then we'll need a motion after that to reconsider the 1,500 feet, or if there's other changes. So motion on the floor is to put a period at the end of homeowners and remove the variance part of item C under H.
Okay, Buskerud.
All in favor? Roll call vote, go ahead.
Buskerud?
Aye.
DeSanto?
Yes.
Farabee?
No.
Hadcock?
Aye.
LaCroy?
Aye. Now, Mr. DeSanto.
I would move to reconsider Section H, Item C, entire paragraph.
Could the motion simply be reconsider Section H1 concerning setbacks, because the proposed amendment would be to the overarching paragraph?
Item H, Section 1, setbacks. I would propose to reconsider.
Second.
Moved by DeSanto, seconded by Hadcock. Mr. DeSanto.
I would move to.
Whoops. We had to vote on it
Sorry,
first.
we got to do roll call vote. Roll call vote to reconsider.
Buskerud?
No.
DeSanto?
Yes.
Farabee?
No.
Hadcock?
Aye.
LaCroy?
Aye. Now we're reconsidering item H under 1.
Number 1.
Mr. DeSanto.
I would move to change the second sentence of number 1 to these are minimum setback requirements, and greater setbacks may be required by the Board of Commissioners.
Second.
Nope, was you finished with that motion?
I'm done with that.
There would also necessarily need to be the amendment to paragraph C that says at least 300 feet, so it's consistent with paragraphs A and B.
And to include in that motion, item H, subsection C, to no mining operation shall be conducted within 300 feet of any existing dwelling, other than that of the mine owner or operator, unless written permission has been obtained by the homeowner.
Is that okay with the seconder?
Did you want to change the language to at least instead of within?
Yes, at least, I'm sorry. Yes.
Motion made, or seconder, okay with that?
Yes, sir.
Okay. Any discussion?
I'd
Mr.
like-
Farabee.
I'd like to call Mr. Doug Peterson to the stand. Podium, mic, whatever.
Thank you, Judge.
You're welcome.
Mr. Doug.
Doug Peterson. I live out there in Hidden Valley, surrounded by the mines. Mr. Tiedemann was kind of padding the numbers a bit. It says dwelling, not property line. He was giving you what he'd lose if the whole property line. And the dwelling would just be a little circle. That's all. And yeah, 1,500 feet is great. That machinery is loud. My house was there long before the mines were. Put in my whole life savings to retire there. And I don't want to sit and listen to all that stuff around me. Thank you.
Thank you, Doug.
So, Chairman?
Hold on, Mr. Farabee, you have a follow-up?
No, that, to add on to that, if Mr. Peterson or whomever can negotiate, this leaves negotiating room, and the fallback is that either side can come to the Board of Adjustment and let those four, and it takes four individuals sitting up here to make that decision. So I think this protects both parties, both the individual homeowner and the mining company, and I think it should stay just the way that I suggested half hour ago.
Thank you, Mr. Farabee. Ms.
Mr. Chair.
Chairman, so Doug understands we can change it. So if you come up and say, this is affecting us, or this is affecting me, that's why we put in may be required by the Board of Commissioners, meaning the setbacks can change based on us. Then you don't have to go to the Board of Adjustment, which costs people more money and more hearings to get their point across, when we can just do it as commissioners, which saves a lot of time and money on both sides.
So you're telling me that if I'm
Doug
Peterson?
Yes, sir.
If I'm bothered by this noise, I have to make an appointment, come down here to talk to you guys while my life is getting disturbed out there? I mean,
Well, sir, even with the Board of Adjustment, you'd have to come down here probably your first time, so we knew about it during the hearing, and the second time, again, for Board of Adjustment. So you wouldn't only come to one hearing, you'd come to two.
yes.
Make sense? So if we did it like this, you'd come to one hearing and you'd say, mining company, if you couldn't find solution with them, of course, you'd come in and you'd say, guys, I can hear this, and by my house or by 10 neighbors, we would like that setback at least a half mile. You could change that through us now. Now you understand?
Oh, yeah, I understand.
Okay.
Well, why are you putting it on me instead of the mining company? Why not leave it at 1,500?
Because it might be 2 miles or it might be a half mile instead when you start having a mine by you. So that gives you the opportunity as well of how much feet they're off of you, not just 3 and not just 1,500. Make sense?
Okay. I think at this point, we're just kind of going back and forth.
Mr. Chair.
No, let me.
Mr. Chairman, can I sneak in here between Hadcock's speeches?
Yes, Mr. Ron.
I agree with this motion, I believe, if there's going to be one eventually. But, we've been at this for over 12 hours. And, it's time when we vote on something and pass it to move on to the next one, not to back up and redo the whole works again. We should have got our opinions straightened out a long time before this. We'll be here all day at this rate.
Yeah, I agree with you, Ron. So motion on the floor is to approve with the changes. Mr. Farabee,
Before
one more
we
time.
vote, if we have 1,500 feet, then the onus is on the mining company. Commissioner Hadcock obviously was wrong again about him having to come down here twice. The individual homeowner.
Let's stick to the issue.
In this case, Mr. Peterson.
Issue, not names.
If there's a variance, he comes down here once for the variance. It's up to the mining company to take the action. Thank you.
Okay, I think we need to take the vote.
Okay, ready? Buskerud?
Aye.
DeSanto?
Yes.
Farabee?
No.
Hadcock?
Aye.
LaCroy?
Aye. I think at this point, I think the commissioner needs a 5-minute break.
5 minutes?
Motion,
Second.
motion and second to take a 5-minute break. All in favor, indicate by aye. Roll call vote.
Buskerud?
Aye.
DeSanto?
Yes.
Farabee?
Yes.
Hadcock? LaCroy?
Aye. All right, we're coming back from break. We left off on page 13. We're going to start back. We left off on page 13. Next, we are going to start on page 14. 14 and 15. Pages 14 and 15. So I'd like the commission to take a look at pages 14 and 15. There were some changes from our last meeting that the staff had made some changes. Is there any discussion from the commissioners on any items on 14 or 15?
Mr. Chair.
Mr. DeSanto.
If we require a transfer to come before the commission and public notice is given of that transfer prior to the transaction of the transfer from the mining company to the new mining company, in a way, that's like if you were possibly facing a bankruptcy and you needed to sell your house or your business. You having to alert the public that I'm selling my house or my business because I'm going to have a bankruptcy in the future. And everybody knows that that's going to reduce the value of your home or your business because potential buyers are going to be aware that you're desperate. In this particular case, what should be a private transaction is now public, and it could possibly create a potential buyer to back out of the deal. And I feel that puts an unfair burden, or it could actually open us up to liability if we, because of our public hearing requirement, that we ruin a business deal. We're not here to regulate business deals. Once that transfer is made, I'm of the understanding that that new mining operation has to agree to the terms that the previous mining company was operating under at that point in time anyhow. So that's just I think we need to change it back to that the transfer request be done through, I believe, the Planning Commission. Just whatever we need to do to avoid having public notification of the possibility of a transfer until the transfer actually occurs.
I guess, I think you bring up some good questions, so we probably need some clarification on that. I think I know where Mark's going with this. With the transfers, there's still notice and so forth.
There's one there. That's the old one.
Okay, yeah, I didn't have the old one. I'm looking for staff's.
You want to use
The old one says, written notice of the transfer is given to the planning department. Could you clarify that for me, Mark?
Which one? Where?
We're on, just for everybody in the audience is, we're in item I, renewals, transfers, and enlargements on page 14 and 15. They go in there and there's subsections under I, A, B, and C.
So Chairman,
Ms. Hadcock.
so the old one says, the upon transfer of interest in a mining operation, the prior owner or operator shall be released of responsibility under the mining permit only if written notice of the transfer is given to the planning department, the operation in compliance with the requirement of section 20 and the 320 and the conditions of operation of the current mining permit, and the new operation and/or operator assumes responsibility for reclamation of the entire permit limit by written, signed, and notarized document, and provides financial assurance of the such reclamation in form of performance or surety bond.
Specifically, what
Mr.
I'm,
DeSanto, go ahead.
pardon me, Mr. Chair. What I'm referring to is number 2, section B, must possess a current South Dakota Department of Environment and Natural Resources mine license for the subject property. A copy of the license must be provided to the planning department prior to public hearing before the planning commission, giving me the indication that it's got to go to public hearing before the transfer takes place. Am I misreading that?
Chairman,
Ms. Hadcock.
sorry, if you look at the top though, on 2, the planning commission on application for transfer of mining shall hold a public hearing.
There you go.
That's what I'm saying, it's when you transfer, maybe I can ask
Yeah. We need some
Vicki or Jessica, when you transfer a mining license, I guess Jessica, you would probably know about transferring mining license. Can you come up here and tell me the process and why we should or shouldn't do A, B, C, D, and what makes it why we should or shouldn't? And if we agree, I don't know, but at least it gives us that process, Miss Jessica.
Thank you. So generally transfers at the state level, there's just a notice that the permit has been transferred. And here, if you're going to have a public hearing prior to the ability to transfer, you could possibly be interfering with the course of a business, and you could impede the ability of a business to conduct that transaction. The person who has acquired the permit through the transfer still has to comply with all regulatory provisions. And then if they don't, they're subject to the revocation under the terms of 320. Okay. And so you still have the control over if a permit is transferred to a mining company that does not follow 320, you can revoke that permit. And if you allow the transfers to take place as previously written under the version that you had just read, that's going to happen. That's going to allow companies to conduct their businesses. Sometimes these transactions are handled confidentially, and a lot of times there's proprietary information that would not want to be disclosed in a public hearing. And so really, the prior version still has the safeguards to allow the county to control the mining operation, but would still allow current mining operations to conduct their business as they normally do. And one thing I'd like to point out is these transfers often happen with the county pits. And so if you have to have a public hearing for the county to transfer their interest in the pit, it's just costing more taxpayer money. And I think that's something that should be avoided.
So follow up.
Yes, Jessica, so if it wasn't like the county and you were transferring and you made that transfer, then they have to come through and us, the new company, in order to comply? Or should that, I mean, how do we know after the transfer, not before, once it's transferred, how do we know that it's been transferred, and if any complaints or anything else have moved, from your company to theirs?
Under the version that was previously submitted without these changes, there are all kinds of safeguards in there already, where the the interest in the in the original permittee is not released. They're not released from their obligations until they give written notice to the county that the permit has been transferred and that the operation has been in compliance with Section 320. And the new operator assumes all of the reclamation duties. And so there's all kinds of safeguards already built in to make sure that the new operator is going to comply with 320. And if they don't, then they're subject to the revocation section of 320. So they could have that mining permit revoked if they do not comply.
Okay,
You got a follow-up?
yes, Mr. Hickey now. Thank you, Ms. Jessica. Since we let one speak, we should have the other side, Mr. Hickey, just to make sure we're
Sure, thank you, Mike
not
Hickey.
missing anything.
The other day when you first considered this at the first reading, I think there was a concern expressed that you didn't know what you were getting when you had a transfer. And I think that was the whole rationale as to why you wanted a public hearing. And remember, we're talking about a consent and non-consent. And so if nobody has a problem or an objection, it's on your non-consent calendar, it sails through. However, if somebody has, if you don't think so, Mr. LaCour? You're shaking your head. I want
Well,
to
I
respond
shake
to
my
that.
head because consent, you're offered, any commissioner can pull that off.
Right, but
And so
but
that,
it's-
it doesn't just fly through, they have an option to pull it off, so that's why I
But they'll only
disagree.
pull it out if there's an issue or a problem, I would assume. They're not going to pull it out just for the purposes of having a hearing or a discussion, right?
That's correct, but it's the insinuating that it was just flies through. I think the statements from the commissioners earlier in this had made the comment that they represent the public, and so if they should know their concerns in that here, so.
But in my experience, unless there is some kind of issue or problem raised by one of the commissioners based upon a call from a constituent, they're not going to pull it, okay? And I think that was the premise upon which we talked about the permitting as well as the transfers, is that if there was a problem, you wanted to know about it before the license and the permit or the license was transferred so that you could address those concerns. What's going to happen is at the state level, the transfer is just a payment of a fee, okay, and a single piece of paper. And so the way we have it now is that at least you're going to notify it, you're going to send a public notice out, and somebody has an objection to the new applicant, they can at least express it. So I think that was the rationale we talked about the other day.
One more follow-up,
Thank you.
Ms. Adcock.
Why I'm asking that. Number one is transfer, when you transfer your property, and I lost my train of thought.
Let me
Okay,
go
so you get written notice from the planning department. And then, what I'm saying is, okay, if the mining company has done everything right, they transfer their property to somebody else, then you want them to come up to us, tell me, okay, so the new company would have to go through the planning department, go through the same process, and say, we're all in compliance.
You're gonna give notice that Pete Lean wants to transfer to Kroll, okay? And you're gonna give public notice so that if people have an objection to that, they can contact you guys, because you're gonna be the ones that are gonna decide whether it's gonna go on the consent calendar or whether it's gonna be a matter that you want pulled.
So I see both sides. Why I say that is because when Kroll or anybody else, I don't care if it's Kroll on top of the hill, but then it was a new pit. Then we had to start looking into, from that transfer, who owned it. Kroll, of course, owned it. Then there was 4 other permits on it, on that transfer of ownership. So there's got to be some kind of solution in between, so at least we have public notification that it's been transferred. Does that make sense?
Yeah, it makes.
After the fact, not before the fact. So what is the solution?
Well, yeah, with all due respect, to do it after the fact is then you're gonna rely upon somebody filing a complaint, or you're gonna allow that company to demonstrate whether they're, following the rules or not following the rules, and whether you've got a good operator or a good new lessee or not. I mean, I think that you want to have that, wouldn't you want to have that examination before to make sure that the company that is receiving the transfer, is getting the property, is qualified and a good company to continue the operation like the previous?
Okay.
Mr.
Ms.
Hickey?
Hadcock, I want to kind of move forward, I'm sorry.
You didn't get your point across, but.
Mr. DeSanto, sorry, but I need to.
Under the previous, after reading of the first reading, I think this is all, I understand what you're saying, but I think it's a moot point because it reads, upon transfer of interest in a mining operation, the prior owner or operator shall be released of responsibilities under the mining permit only if written notice of transfer is given to the planning department, but more important, the operation is in compliance with the requirements of Section 320 and the conditions of operation under the current mining permit, And if someone had a problem with the operation could have already been going on for 2 years under the, and would have been in compliance with Section 320, and therefore whoever had a complaint would have come to the previous owner and said, hey, you guys aren't operating within the boundaries of the ordinance, and I want to make a complaint. So they've already addressed that in this ordinance.
But the concern isn't with the old operator, the concern is with the new operator.
Yeah.
But the new operator has to comply in order, before we even release the old operators from their responsibility.
Okay, but I guess that's the question, is how do you know that the new owner is going to comply with those requirements if you don't even have an opportunity to examine it before the transfer?
Well, if they're not, we can issue a stop order.
Well, again, what I would suggest, and I thought that's what we talked about the other day, is that you wanted to avoid having to later on do stop orders. You wanted an opportunity to examine it before the transfer went through. I mean, that's my recollection of why we put it the way we did it the other day, and I don't know why that's changed.
Thank you, Mr. Hickey.
Thank you.
I guess, George, did you have a comment before I make a comment?
Well, I do.
I'm asking you.
I do, yes, and I find it kind of interesting. If I heard her right, Miss Larson or Mrs. Larson's comment about later on revoking a permit. Well, I guess if I'm in the process of trying to buy somebody out, and I understand the dealings, there should be confidential. But if I get to the point where I'm about to make a deal with a company or an individual, then I've got this fear hanging over my head that the Board of Commissioners can revoke my permit. I kind of want to know all that up front. You can't have fear both ways. No, what's wrong with having it out in the open? Well, the transfer public hearing, you're trying to hide that from the public, but yet we, the public, can revoke that permit. I wouldn't buy into a circumstance like that, knowing that yeah, I do all this confidentially, and then I have to fear the county government taking my permit away. No way in hell would I make a deal like that. Up front. Thank you.
Thank you, Mr. Rick. Ron, did you have any comments on this?
And I understand where the mining companies don't want to do it up front because, all of a sudden, I've never bitten into George's overreach of the government, in which he has now changed his mind on this item. But I think that having a hearing before the deal is made, that smacks to me of government overreach.
Thank you. My comment on this, now that we're moving forward, I'm echoing Ron and I think Mr. DeSantos and Ms. Hadcock. So I think the previous one, better ordinance, am I getting that right, Mark? That you were looking at the previous ordinance fit this better because I think in order to do fair business, that needs to happen. I mean, you don't want to, it's going to be tough to sell your business all businesses like to, they do things sitting down in a room and talking together, and then they do the transfers. And I think there's safeguards in all the policies that we've written so far, that there's safeguards in there to accomplish what we want to get done. So with that, I would look for a motion on the floor.
I would move to change section 2, or section I, number 2, transfer of permit, back to the language that, of the first reading. Upon transfer of interest in a mining operation, the prior owner or operator shall be released of responsibilities under the mining permit only if written notice of transfer is given to the planning department, A. B, the operation is in compliance with the requirements of section 320 and the conditions of operation under the current mining permit, and C, the new owner and/or operator assumes responsibility for the reclamation of the entire permit limit by written, signed, and notarized document, and provides financial assurance for such reclamation in the form of a performance or surety bond.
That's the motion.
That's my motion.
Second.
And seconded by DeSanto. And I'm assuming, I mean, not DeSanto, by Buskard, I'm assuming we're on 14 and 15. You just want to do that separately?
That separately, yes, please.
And that's underneath transfers of item 2. He wants to revert. His motion was made and seconded. Do you have any discussion, Mr. Farabee?
Let me repeat for the record that I think we're on shaky ground. This thing all started, as I made a comment last meeting. If John Tellywood had a permit for that gravel pit up on top of the hill, and that's what this is all about, and I think everybody realizes that, the transfer could have happened without we, the government, the people, neighbors. Been a done deal without any transparency. Since mining is of this significance, I think we need maximum transparency, and I totally disagree with government overreach.
Thank you, Mr. Farabee.
Thank you.
With that in mind, motion on the floor is for, like I said, under items 8, renewals, transfers, part 2, transfer of permits, changing it to what it back was before. We got that, Jerry? Okay. All in favor indicate by saying aye in a roll call vote.
Buskerud?
Aye.
DeSanto?
Yes.
Farabee?
No.
Adcock?
Aye.
LaCroy?
Aye. So that brings us back to, still in item I, renewals, transfers, enlargements. There were some other changes throughout that. And that goes on to page 15. Commissioners, please take a look at those. Is there anything that you think needs to be seen, changed? As you see, the red is what was changed from our last meeting. 14 and 15 still, because we just voted separately on item 2 under I. And so we still got to approve these other changes on pages 14 and 15 under item I. If you see no other changes and you are okay with the changes that were made, I'd look for a motion to approve pages 14 and 15 with the changes.
I'll make that motion.
Second.
Moved by Ron Busker, seconded by Ms. Hadcock. Any discussion from the commission? Seeing none, all in favor indicate by saying aye in a roll call vote.
Buskerud?
Aye.
DeSanto?
Yes.
Farabee?
Yes.
Hadcock?
Aye.
LaCroy?
Aye. Next, that brings us on to page 16. And let's do 16 separate, and that's complaints and revocations, J and K. There were some numbering changes. And under K, mining operations, just the spelling's been changed. Item 4, owner-operator failed to perform or complete required corrective action as determined by section 320J. If you see no changes that need to be done with those, I'd look for a motion to approve page 16.
Hold on.
Has everybody had a chance to look at page 16? I'd look for a motion to approve page 16, J and K, with the changes noted.
Move for approval.
Moved by Mr. DeSanto to approve page 16 with the changes. Is there a seconded by Ron Buskerud? Any discussion? I'd recognize Brittany.
Sorry, I just have one wordsmithing on the notice of hearing shall comply with the requirements of section 320E of should not be struck. So it should be notice of hearing, not notice hearing on the very last sentence.
Oh, it says
Notice.
of the shouldn't be struck?
Just the should be struck.
That the should be struck.
Correct.
Okay. So I think that was okay with the motion maker and seconder. Okay, with those changes, roll call vote, please.
Buskerud,
Aye.
DeSanto,
Yes.
Farabee,
Yes.
Hadcock,
Aye.
LaCroy.
All right. Next, that brings us to page 17. Under page 17, we have sections L, M, and N. Commissioners, please take a look at those pages.
May I
Ms.
interject?
Oh, sorry. Recognize Ms. Michelle.
Thank you. Michelle Hoffman, State's Attorney's Office. While the board is reviewing that page, could we take a 5-minute break? I'd like to meet with representatives of both the concerned citizens as well as the mining representatives. I think we may come to agreement on possible language in subsection N.
I would think that'd be a great idea.
Second.
Would I make the motion?
Yeah, you-
Roll call vote, take a 5-minute break so they can concentrate together on this.
Okay.
Thanks, Ron. Hold on, man. Roll call vote.
Buskerud,
Absolutely.
DeSanto,
Yes.
Farabee,
Yes.
Hadcock.
I need a speech first. Just kidding.
Aye. So we come out of break. With that, I will recognize Michelle Hoffman.
Michelle Hoffman, State's Attorney's Office. I do have some proposed language changes to subsection 2 of 320N, and I'm going to read them. The purpose behind the changes is to clarify the intent of the ordinance, the language. The intent has been to limit the legal nonconforming to the lot where there's currently excavation, so that the excavation does not expand to contiguous lots or other lots held for future use. So with that, the first line, I propose that mining operations be struck and substituted with the words excavation activities. Active would be struck, as I don't think it's necessary. And then A, B, and C would remain the same. The next paragraph would again strike mining operations and state excavation activities that are a legal non-conforming use do not require permit under section 320. And then I would add the following sentence to clarify the intent of the legal nonconforming language. It would say, however, legal nonconforming use may not be expanded beyond the boundaries of the lot on which the use was initiated at the time of enactment of Section 320 without a mining permit. And just for the edification of the office, I had earlier used the word tract, but decided lot would be better because we actually have a definition of lot currently in our zoning ordinance, which is defined as a portion of a subdivision or any other parcel of land intended as a unit for transfer of ownership or for development or both. That does not include any part of a right-of-way or street or road. And then with that, the final paragraph would again, after the 4 criteria, that would be forwarded to the planning director for registration of the legal nonconforming use, would add the sentence, further information may be required by the planning director, period. And then the next paragraph would be, in addition, you would strike all mining operations and again substitute excavation activities. I do not believe there's any objection to the proposed change in language. I would certainly encourage any individuals in the audience, if they do have an objection to that language, to come forward. But I think we could vote on those changes, and then there's one big issue that the parties can't agree on, and but if we can approve at least the changes in those languages, then we can deal with, I think, what we have as the remaining issue.
The remaining ones.
But I would invite any comment if anyone is in disagreement with that change in language.
Is, just a second here before I get started, is the wish of the board to be able to see these changes that Ms. Hoffman talked about written in so we can see them as written?
Carrie's.
We could do that while you entertain.
Okay, why don't you do that now? First hand, Jessica, I seen was him back there, and then I'll go to you, Jessica.
Quentin Riggins on behalf of GCC Dakota. In speaking with council, other parties relative to these comments and changes, the biggest concern that I have is relative to the definition of tract. It's still unclear to me what tract is. In particular, GCC Dakota has a 172-acre parcel that's all part of the same permit that I would argue is considered one tract. There's currently excavation on that tract. It's all land that was acquired from the state of South Dakota directly pursuant to the original sale, which is why we advocated for the inclusion of the original language specifying that pursuant to that statute, this land would be considered exempt. With the definition of tract included, I do have some significant concerns that as presented, it's not defined enough to provide guidance as to what that definition means and only invites litigation. I would again reiterate that, Mr. Farabee was talking earlier about, a bargain for exchange as it related to permit transfers. Here we had a bargain for exchange with the state of South Dakota. Here, the state of South Dakota was looking to sell a product, the cement plant, and would not have found a taker were it not for the inclusion of this statutory language that specifically exempted this property. The state bargained with my client in order to achieve that. That's why we're advocating for this additional language. We believe our concerns about the tract language would be mitigated by the adoption of that language, but I am concerned as we sit here with it as defined.
Okay, thank you, Glenn. Jessica.
We would agree with the majority of the changes, with the exception of using the word lot. Even though there is a definition of the word lot, most of the properties that are being mined are not subdivided into lots. I think the better word would be parcel. There are legal definitions of all the parcels that are owned by the companies, and so if you use the word parcel, they have maps and they can show you the parcels that are that would be indicated. And so with the change from the word lot to the word parcel, we would have no objection to any of these changes.
Thank you, Jessica.
Subsection C, paragraph below.
I haven't had time to absorb what all of this means, but I'm going to agree with the lady just before my concern for the use of the word lot. It's my impression that a lot is something where an action has been taken to take it away from just being a quarter section of a quarter section of a quarter section. And I think there's going to be mines who are defined by a quarter section of a quarter section. And so I think lot is maybe not, I mean, I don't understand what they're doing, but I question the use of the word lot. I don't know what the word parcel means.
Thank you, Nancy.
I think parcel is broader than lot.
Mr. Hickey.
Mike Hickey, I think we would go for lot as opposed to parcel or tract. We have some other concerns, but with respect to this one, I think that's fine.
Mr. Hickey, why would you prefer lot over parcel?
A parcel could be 5 sections. You know, there's no definition of parcel. We were talking about earlier, if you've got excavation, like right here, and let's say that's in section 1, and you happen to own section 1, 2, 3, 4, and 5, and you've never done anything in those other sections, and when you use the word parcel, well, that's everything I own. And I don't think that's consistent with what I think the diminishing asset doctrine is at all. I think it has to be limited to the particular area that you're talking about. So
Thank
that's
you.
why I think parcel is just too broad.
Jessica, just to clarify, you wanted parcel, right? Okay. Brian.
I just want to clarify what Mr. Hickey said. I believe that the reason that they want to use lot instead of parcel is so that they have more control over the Kroll situation. And this is the perfect point to, or time to make the point that we're arguing this for one operation, and there's 193 other operations to consider. So parcel makes more sense for all of the other operations. Lot makes sense for them wanting to control what's happening on the Kroll property. Thanks.
Thank you.
Mr. Chair,
Mr. DeSanto.
if parcel is defined, we put a definition of parcel in here, to limit the use of that word to the permitted area, would that be satisfactory? Anybody?
Let me think a little bit.
Chairman?
It sounds like the lack of definition is what we're concerned with.
Let's let Jessica answer and then.
The mining operations already have permitted areas on their construction permits and state permits. That could be used as the permitted area. And in addition, I believe that parcels are delineated by the county for tax purposes. And so that could also be considered when looking at what a parcel is.
Okay. Thank you, Jessica. Mrs., you done?
I'm done.
Ms. Hadcock.
And I agree with both sides. I thought parcel was like limited to the mine operation, like this is a parcel of property, meaning it could have 15 lots on it or something else. I don't know what the word is, subsection. I have no idea what to use on it because I don't think it's parcel and I don't think it's lot. Lot is more defined, I thought, was you had to, once you made a lot, if I'm correct, PJ, it's more like subsectioning and subdivisions. It's a lot. So tell me why we should, you got a better word than parcel or lot, or why do you agree with parcel or lot?
They're actually, we use them interchangeably. lots, parcel, tracts, they get used all the time. There is specific differences, and I know the Register of Deeds knows the specifics of those. Looking them up in the APA dictionary, they refer back and forth to one another. So,
But there's a parcel with a lot in it, is what I'm guessing, or a
yeah, a
tract of
unit
land
for a
in it.
unit of transfer,
But I
yeah,
thought the parcel was the overall, and the lot was specific to a certain area.
not always.
Uh-huh.
Be-
All right, so we're gonna go, it looks like Jerry's made the changes. And these are the changes that were agreed upon, right, Michelle?
With, apparently with the exception.
Exception of lot and parcel. And Jerry, could you point to me where the lot and parcel is coming in? Okay. That's the only spot. Be underneath the excavation. Okay. Change that was made. Ron, are you able to see all that?
Not really, but I do know, I guess I've worked with it long enough to know that parcel is a term used by the Register of Deeds and by equalization. So I'm comfortable with the term parcel, quite frankly.
All right, thank you. That's good to know. Any commissioners have any other comments on those changes? From the looks of it, we have pretty much of agreement from everybody except for the wording of parcel and lot. I'm personally okay with parcel. Because I agree with Ron that I think it goes with equalization and so forth to keep it standard, but I'd be willing to listen to what the commissioners have to say.
So Chairman,
Ms. Hadcock.
a parcel could be 160 acres, or a parcel can be 20 acres. So defined on mining operation, do we go by mining license, by parcel, or do we go by parcel or lot that we define it? Because you said it could interact. So, okay, I'm going to bring up Kroll. So if we say the parcel is 160 acres, and they're in lot 9 and 10, which is lot 9 and 10, not parcel, but it's in a subsection of a parcel that has 160 acres. You see where I'm going? So then it'd be lot 9 and 10 in parcel 64. So if we say parcel, does it include all of that area and the lot? Because that's where I'm saying Mr. Hickey's going. Or are we saying lot because, and then here's the other argument. Then Pete Lean they didn't make lots. They have parcels. Because they don't have section 9 and 10 as a lot, they have it as in a parcel and they don't define it as lots. Am I correct? Or do you guys have lots? By chance, Brian or Danielle? Tell me how you subsection mining.
I think I have the answer to this.
Yep.
I hope I can answer this for you. The way we do it when we map it by our parcels, which is what equalization uses for the taxes. So we might have several parcels in one section, or it might just be 2 or 1 parcel per section. But what you're talking about, I believe, with 9 and 10, those aren't lots within a parcel. Those are 2 different parcels.
Okay. That's what I needed to know.
So I think that's a little bit different. So a parcel seems like it would be all encompassing and 4 or 5 sections could fit in there, but what it truly looks like when you look at the tax maps, a section would be divided into several parcels in most cases, unless the land's never been touched and just been transferred over decades by the section, then it might be a full parcel, but that's pretty rare around here.
Thank you, Danielle.
Mr. Chair.
Mr. DeSanto.
I think that we should use language congruent with what's used in the Board of Equalization, but it also is covered under the sentence expanded beyond the boundaries of the whatever, expanded beyond the boundaries of. That pretty much regulates.
The only person I haven't heard from is Mr. Farabee. Mr. Farabee, any thoughts on this before I ask for a motion?
I got a whole bunch, but probably restrict it just to this. I think parcel is part of something. I think somebody's saying, intimation is that parcel is a total unit. Parcel is part of something, I think. Anyway, I got a lot more to say, but I'm not going to say it here.
Okay. So with those, I think we did a good job. I want to thank the groups for going in and doing some own personal work in the back room, and I think coming out and only having that disagreement is very good. Oh, I thought that was it. Dang. But,
That was the easy one.
okay. So with that, I would look for a motion from the commission to approve.
Hold on.
I'm sorry,
Go
Commissioner
ahead.
LaCroy. I just wanted, just before you vote, to point out that the definition of lot and parcel is very similar and interchangeable, where our lot definition says a portion of a subdivision or any other parcel of land intended as a unit for transfer of ownership or for development. Parcel is defined in the APA dictionary as any legally described piece of land designated by the owner or developer as land to be used or developed as a unit, or that has been developed as a unit. So they're somewhat interchangeable, but I just wanted to point that out.
Okay. Now, Michelle, on the rest of this, page 17, is it on the next page that we're going to have some more discussion on?
The discussion's going to come down to whether the planning department is the final decision maker with regards to whether something is legal nonconforming upon registration, or whether there should be some other process in determining.
I see. And that's under the enforcement part.
Well, it would just be, it's a question of whether there would be additional language added. Understanding that this was going to be an issue when I received some of the comments, I do have, depending on what the board decides, I do have language prepared, but I don't think it's appropriate for me to share that at this point in time. I think the board needs to decide who they want, how they want the process to be.
Okay. So with the understanding that she's made the changes that's been agreed upon on page 17, I'd look for a motion from the commission to approve the changes, and then in their motion, decide whether it should be parcel or lot to be included in that.
I would move to approve with the changes and the language parcel.
Is there a second? There's a second from Bus Group, motion by DeSanto. Any further discussion? Seeing none, all in favor indicate by saying aye, and a roll call vote.
Buskerud?
Aye.
DeSanto?
Yes?
Farabee?
Yes.
Hadcock?
No.
LaCroy?
Aye. Okay. That brings us to item O, or LMN O, enforcement on page 18, which goes on to page 20. I don't see any previous changes from our last meeting. Does staff have any We have Mr. Hickey.
Before you leave, Ann, I think Michelle has indicated that there are some issues with respect to that. It's not included in the existing language, but I think the parties would like to address the commission concerning some possible additional language in N before you go to O.
Okay. So
And if I misspeak, Michelle, you correct me.
I was moving right along, Michelle. You said there was some other stuff in N that we needed to address? Is it N that we,
I think that, well, first of all, before we end today, we do have a definition for parcel that we probably in light of and should add to our definitions. But I think Mr. Hickey's referencing the question of who should decide. Under N currently, legal nonconforming operations must register, and those registrations are reviewed by the planning director. I think the issue that needs to be discussed is whether that's the process the board wants to follow or if there's some other process. And I think there's disagreement between some of the interest groups in terms of how that should be decided.
I'll take some comments on that. Mr. Hickey, since you brought it up, you'll go first.
Thank you. Where do I start? As it's currently in place, basically, there's a registration process where mining operations will file some documentation with the Planning Commission. We've got some concerns about what kind of information is being supplied, number one, and then secondly, we have a major concern about once that information comes into the Planning Commission, how and if it's disseminated to people outside of the Planning Commission and the mining company. There's no provision in the existing language that any of that information be shared with other people who are affected by the expansion of the operation, or other people who have a negative substantial impact on their property rights. And I don't know if you had a chance to read my letter and the California case that we talked about. They actually define and discuss I guess the conflicting or the property rights of both sides, not only the mining company, but also the people who are affected. In that case, and it's Calvert versus County of Yuba. It's a California case, and remember, California is the jurisdiction upon which the diminishing asset doctrine is pulled from in the Wyoming case. And so this is California talking about the very doctrine that you're talking about. And in that case, the petitioner in that action, they say, presented a typical example of the property deprivation at play for adjacent landowners. In the complaint and petition, Calvert, who owns house and ranch within 300 feet of Weston's property, alleges that Weston's mining operation exposed his property to dust, noise, air and water, and toxic pollution. Furthermore, Western's operation had damaged at-risk species of animals. Calvert has adequately described property deprivation as substantial enough to require procedural due process. In addition, he complained about the traffic and things like that. And the California court said that's property rights that need to be protected. And so basically they required that notice be given to people who have an adverse substantial impact on their property, and that they have an opportunity to at least comment on that process. And the other thing gets back to our whole fundamental question is, who's going to make these decisions? You know, this commission earlier decided that they wanted to decide on new permits, and this is basically an extension of that same argument, is that we believe you need to decide whether or not this pre-existing use or this non-conforming use can lawfully be expanded, weighing the interests of the two parties on the two sides. And we believe that you should make that decision as opposed to the Planning Commission. And then there has to be some kind of notice Otherwise, it's, it's going to be a secret deal between the mining company and the planning commission, the planning director. And we believe that there has to be notice to the owners that are going to be adversely affected by a proposed expansion, especially if, under the definition we just talked about in terms of parcel, if you define parcel as all of the land owned by the mining company, that could be miles and miles away that nobody is going to know about. And so I think in fairness, you need to have some kind of provision to alert people to that.
So bottom line, Mr. Hickey, is you're wanting an executive summary. You want the commission to make the decision
On whether or not that existing use is consistent with the diminishing asset doctrine.
Okay.
And then that's the first thing. And then secondly, we're also asking that in the current language, you've got that the mining operation is needed to comply with the general regulations of Section G. You see that in that second that paragraph right under ellipsis 4. And Michelle indicated that she's changing the word mining operation to extraction activity, I guess. But
yeah.
What we're talking about down below is the last sentence. It says, that the planning director in his or her discretion, and we think that should be the Board of Commissioners, number one. And then secondly, the type of information that the mining operation needs to comply with, in addition to subsection G, we would submit that it should also include section F, numbers 2, C, and D, which is basically a site plan and an operational plan.
Okay, thank you, Mr. Hickey.
Those are the things that we believe need to be added to the current language. Thank you.
Jessica Larson, attorney for Peatling and Sons. I just want to point out a couple of things. Who makes the ultimate decision? I think the planning department is set up. They have the expertise and the resources to go out and investigate and make these decisions, and that's why we have the planning department. And so I think they're the proper decision maker on these legal nonconforming uses. Regarding notice, these are existing mines. They are already mining. Their neighbors know that they are mining. And with respect to Peatling and Sons, all of their property is fenced with signs every 300 feet that say, this is a future mining site. So I believe there's already notice. So if there were complaints, they should be complaining now. They are welcome to complain along the way. But they have noticed that these mines are existing. There are plenty of safeguards put in place throughout this entire ordinance and in limits of operation to protect neighbors. The mining companies have to follow all of the regulations in G, and they also have to follow the regulations set forth in their current permitting, which is under 507A, which includes things like maintenance and inspections. There are additional requirements regarding water courses and floodplains. There are requirements for discharge detection and prevention in 507A. In addition, there are rules for how the planning director may issue stop work orders. And so there are many protections in these legal nonconforming uses. They have to comply with what they had to comply with before, plus all of the requirements in Section G. And finally, I noticed that Mr. Hickey mentioned proposed expansion. I'm not sure what he was talking about, but if they expand outside the boundaries of the parcel in which they're mining, they have to apply for a new permit under 320. They cannot expand outside of a parcel where they are not currently excavating. Otherwise, they would be subject to the permitting requirements in 320. With respect to the requested additional language that Mr. Hickey would like to add, the additional requirements on, F, 2, C, and D, I'd like to ask somebody up that actually prepares these reports to talk about that and why I don't believe it's necessary.
Who would you like to ask up for that?
I'm going to ask Danielle, please.
Danielle, please. I'd like to have that clarification also.
Okay, so as we've gone through, most of the work in the application process is truly going through, building that mine plan out, developing it completely for the next 50 years. We usually develop our plans 5 years out. That would be the benefit of being grandfathered, is that we could continue to operate as we currently operate. Whereas if we have to go into this now, we have to go through an entirely different process to develop a mine plan for the remainder of the property throughout here. So really on the application side, where we've talked about where the expense is to the applicant, that's where it truly is, on that design and process portion of it. If you're going to include that into the grandfathering, you truly are not grandfathering at that point. You're just making them go through the application process, since that's the majority of it anyhow.
Thank you, Danielle.
Can I ask her a question?
Mrs. Hadcock.
So Danielle, in description of operations, can we put including site plan in on that,
Yeah, I think a map is more than appropriate for, just to attach it to that document that you're submitting to the planning commission. I think that, or the planning department, I think that's more than appropriate.
so again, operations and site plan, what's the difference? Are
The
they the same?
operations and site plan, when you go through an actual operations plan and when you look through the definitions through all of that, that requires the whole reclamation plan and everything. So we're talking slopes, coverage for any of the reclamation overburden, where we're piling everything, where we're putting everything
Okay.
throughout the entire process, not just right now. So
The site plan is right now, and
Right.
operations is the overall.
Yeah.
So we've got it covered.
Right.
Okay.
Well, let me.
Oh, you still follow up?
Sorry, because if you have a site plan, meaning if I see your site plan, it might be easier for me to decide that you aren't where you can operate or where you're going to operate. No?
If you see our site plan, then you can truly see where we are operating currently, where we have excavation currently, so you can make that determination on that three-prong test, which is what you want to do.
So the operations and site plan can go together?
The operation plan, that's the farther out picture. That's your plan throughout the full life of that operation.
I guess that's what I'm saying. So if it's limits of operation and this is non-conforming grandfathered in, then I'm going to have to agree with Mr. Hickey, then the operations is different than the site plan. That I would like to see the site plan to make sure if we did do a look at your operations, that site plan you have included where you've already been operating.
Okay, I think what you're asking for then is you want a site plan with a total disturbance boundary.
Yeah, what you said.
I believe that's what you're asking for, and I think that probably satisfies Mr. Hickey's request too. He just really wants to see ultimately
Where you're
what's going to
mining
be
now.
touched on that parcel, and I think that's fair and appropriate.
Okay.
Where would that be at? Now, Miss Nancy, at this point, you're supposed to be requested for information. Does the commissioner take comment from Miss Nancy? I have a question for her.
Go ahead, Miss Nancy. Let her speak.
I want to point out the difference between F and G. In F, Part 3, Drainage and Erosion Control Permits, this is your section on water quality. And that occurs in G, that includes in F rather than in G. And a lot of the stuff in G is about stuff that's protective. But I would suggest if you're just going to do G and not F and G or parts of F and G, which might, splitting F up might be useful. But I think 3, drainage erosion control permits should be moved to G if you're just limiting G. And this is particularly relevant to the fact that for the next year or two, 320 is going to be applied to hard rock mining. And hard rock mining, water quality is a huge issue. And you're also going to have grandfathered in hard rock mining. So it took us a year or more to do this on sand and gravel. How long is this going to be in place, being the stopgap measure for minerals?
Thank you,
So,
Ms. Nancy.
Thank
So
you.
I think the bottom line is the disturbance boundary has a lot to do with what she's saying, meaning
Yeah.
disturbance has to do with that,
Yes, so
Okay.
I would look a motion,
to add
we've
that.
already, I'd look for a motion to add that in.
That'd be my motion.
Is there a second?
It's a descriptions of operations including disturbance boundary. That way you could tell where that mine was operating at one time through the disturbance boundary.
So you're adding that as a motion under C. I don't have a problem with it.
Be under number 2, under description of operations including disturbance of boundaries. Did you see that? Descriptions of operation including disturbance boundary.
Second for discussion.
Motion's been made and seconded to add including disturbance of boundary.
Boundaries, whatever. I think it's part of the operation.
5 to be site plan with global disturbance boundary?
No.
Danielle Levers, I would just change it, description of operation, including site plan with disturbance boundary.
There you go.
I'd get rid of global, I'm not, yeah. We're not mining that much.
More specific, Michelle, through site plan with disturbance boundary.
Okay. There's been a motion and seconded. Further discussion. Do you have any more discussion on that, Mark?
Nope.
Ms. Hadcock?
Well, thank you.
Mr. Farabee?
I think Mr. Dean had a comment.
Mr. Dean, did you have a comment? Come on up, Mr. Dean. Nope. Danielle, did you?
No, I was just going to whisper something.
Jim Dean, Coldstone. Just wanted to double up on what some of the people have said about the registration and things that have already been done on mines that are actually being legally mined in the Black Hills, Pennington County area. There's already site plans done. There's already operating plans done. All that stuff is already on file at the state. So the planning commission, the planning people should be able to just look at that, and if they see that you're not an outlaw and you are actually legally mining, and you have all your everything pretty good, they should be able to make the decision, and we should be able to carry on until we go to an expansion or a new site.
Thank you, Dean. I think, Danielle, did they correct the wording you wanted? Everything's fine? We have a motion on the floor to add that changed, including the site plan with disturbance, with the disturbance boundaries. There was a first and second. Further discussion?
No, we're voting on just this and not the entirety of N.
We already voted on N with all its previous changes. This was added back on.
We're voting on just that and not the entirety of N.
Correct, because yes.
We got some more N work to do.
Not from my understanding.
Well, we got some more N work to do.
And here
So I got no problem voting on this as long as N is still open.
Well, we voted, from my understanding,
Voted on N already.
we voted on N with the changes in red that's up there now.
Yep.
Yeah. So the items would be,
Michelle Hoffman, State's Attorney's Office. I think the confusion is that there's been language that the board appears to be in agreement with that Ms. Weavers has suggested, but I don't know whether you've addressed or have decided, maybe there's no motion to make any further changes, but whether you've
I just
addressed.
made a motion to accept those changes.
No, but the issue of who's going to decide, who would decide, and if that's included in that, that's fine.
We didn't change it.
We haven't done that yet.
we didn't make that change. We approved with the previous changes on N, and
Now we-
second motion was on this change.
And then we need to work on the.
Then we probably need to work on the decision maker.
that we-
So we'll have to revisit N in its entirety.
Some more. We need to work on N some more.
Let's take care of the motion on the floor, and then we'll go back.
Thank you.
So the motion on the floor is to approve the change in N as it's stated with, including the site plan with disturbance of the boundaries. All in favor indicate by saying aye. Roll call vote.
Buskerud,
Aye.
DeSanto,
Yes.
Farabee,
Yes.
Hadcock,
Aye.
LaCroy.
Aye. So my understanding is I thought we approved most of N with the changes. Then we went back and we added underneath section 2 the disturbance. But it appears there's more discussion on whether it's the planning commission who makes the decision or if it's, oh no, it's the planning director, am I right?
Correct.
Or if it's planning commission, or if it's the board of commissioners. So I would open up the comment to Mr. Farabee on that.
Well, I think I was hearing Mr. Hickey, right, that he'd like another subparagraph or subsection or whatever to clarify who the final say is on legal nonconforming. And before he gets up here, I don't see anything in there right now as to who says anything about legal nonconforming other than the applicant comes in with the standardized form and name and description and date nonconforming, and that's all it N says to me right now. And so I think Mr. Hickey must have some language for us to add on to N.
Mr. Hickey, can we keep it strictly to the add-on language? That'll keep it simple.
Well, I think to be simple, it would be the county commissioners make the decision, the final decision on existing uses, just like they make the decision on new permits. I mean, I guess that's my bottom line, is I think this board needs to make those final decisions.
So Mr. Chair,
Mr. Farabee.
then there's a subparagraph 1 and 2, would you make that subparagraph 3, or would you submerge that under one of the other ones?
Well, I think you could probably, you could just change the language that in terms of the last sentence of the paragraph that starts in addition. You know, you're gonna require the submission of the requirements of section 507A of the zoning ordinance, submit a reclamation plan and post a surety bond, if required by the planning director, for final decision by the county commissioners. Again, it's just the same process that we've talked about before, and whatever the wording is to make that clear, I don't really have any problem with. I'm sure Michelle can come up with better language than what I'm just giving you right here today, but it has to be that
It's
this
in that
commission.
last section that you're talking.
Yep.
Okay. Any further discussion?
So you would be okay if we had a subparagraph 3 that said after the registration is complied with and a registration is entered and then all of the individual requirements are met, then that all be presented to the Board of Commissioners for approval.
Final approval, right. And then, and that, again, I don't want to ignore the fact that, again, I do have concerns about the lack of notice to people. I think that there should be notice to people, and then the final, the commission makes the final decision.
And then, Mr. Chair, from my viewpoint, it's a one-time deal. It's a one-time deal for existing operations. Once they register and go through all the hoops and get our blessing, it's done deal.
Well, under your definition.
Unless there's complaints, obviously, but I mean, they don't got to do this again and again and again. It's,
Yeah, under your definition of parcel, that's probably right. I mean, if parcel can be half of Pennington County if I own it all, so that's
Okay,
right.
Mr. Hickey. Further discussion, Ms. Hadcock?
We're saying right now, there's 194 companies, 100 in operation. We're going to send them all through us? Is that what we're saying?
and a lot of them can be consent calendar, right?
If they expand, they have to do that, but if they're already in operations, we're going to go in and take somebody that's already in operation and say, you're going to go through a process now just to keep operating like you are. And you're going to, when you do that, you're going to have to go through subsection G when you're doing that, and then comply with these. And we're going to run that through us 100 times. And if it's on consent calendar, it's fine. If it's not, it's going on regular agenda.
Mr. Chair.
I'd like to get some clarification first, Mr. Fairby.
Okay.
Ms. Hadcock has the floor. You done, Deb?
Yes.
Clarification from Michelle.
Michelle Hoffman, State's Attorney's Office. I do want to point that the argument that is presented for hearing of these matters concerning legal nonconforming really is much narrower than presented. The case, and first of all, the language that's that's proposed and that's been approved doesn't come just from Wyoming or California. It comes from the myriad of jurisdictions that have acknowledged the law of diminishing assets. But the California case is actually very limited. This was a case where private citizens brought an action claiming that there had been a taking of their land. So it's rather interesting because you have the mining industry that would assert you're taking their property rights. And this was a case where abutting neighbors were arguing that their property rights had been taken. But what's very important to understand is the California Supreme Court said this hearing, this due process argument only came into play when the abutting landowners' property rights were substantially affected. And in that case, you were dealing with homeowners that were 300 yards away. But more importantly, that particular operation sought to grow from 1,200 acres to 3,400 acres. So the California case does not stand for the argument that there should be a hearing in every single instance. It's just, so I suppose, there would be nothing that would preclude property owners from filing an action claiming their interests have been substantially impacted. But I just wanted to clarify that particular issue, that it's not a hearing for every single, in every single application. And so that comes back to really what the board needs to decide. They need to decide whether they want to keep the language as is and have the planning department decide. Another option would be a notification of abutting neighbors. And then if they filed a request for a hearing, then you could have a hearing. Or Mr. Hickey's option. But I do believe some of the, individuals who represent the mining industry would like to have some input on that.
Thank you, Michelle.
Mr. Chair.
Mr. Fairby, at this point, I'd like to speak. I've let everybody else speak. Personally, I think we've worked hard throughout all this, and we're getting stuck on this. And I understand it's a sensitive nature for some, but I am in support of the way it is as written. And I'll allow some more discussion, but I just wanted to let everybody know where I'm at as we move forward. Mr. Fairby.
To kind of put things in perspective, I don't imagine there's 194 individual mines that are not multiple owned. I don't think we're looking at 194 people coming to us. I'm guessing there's quite a few multiples. So, and what that number is, I don't know, but I'm guessing there's. Does anybody have any idea how many multiple owners there are of individual mines?
Brittany?
But this is a one-shot deal, and then the Pennington County then is blessing, so to speak, blessing or not blessing, the legal non-conforming operations in the county. And then the public, our bosses, then have a right, full transparency to see what's going on.
Thank you, Mr. Farabee. Brian, I'll call on you for, no, go ahead. I'm calling on you now.
I was just gonna answer Mr. Farabee's question. There's 194 permitted operations. 100 and some are active, but each one of those permitted operations would have to go through this process. It wouldn't be per owner. It'd be every operation.
But follow up, you, the owner, could bring in 10 or 15 or whatever all at once.
You'd have to bring in a lot, that's correct.
But you can bring them in all at once. So you got one appearance.
Depends on, I guess, how you get them completed, yeah. Depends on the timing of that. So.
Thank you, Brian, for those. Ron, do you have any comment on this?
Well, yeah, I think it's immaterial how many mines there are and how many owners there are. We're trying to be looking at what's the best for the citizens of Pennington County, and I don't think how many, if there's 1 or 100, make any difference. Time to move along.
There you go. As I said, I think we're taking the comment. I would look for a motion. There is no motion on the floor. We did approve N with all the changes and with the additional change. I guess I would look for a motion to approve N with the limits of operations and all the subs underneath it up until O.
No approval.
There's been a motion to approve N as is with the changes.
Second.
Seconded by Ron Busker.
I have substitute motion.
Mr. Farabee.
Under subsection N, add paragraph 3 to require Pennington County Board of Commissioners to hold a hearing and approve pre-existing parentheses legal non-conforming mining operations in Pennington County after all the registration and other requirements are satisfied.
There's been a substitute motion by Mr. Farabee to add a subsection 3 to require, require approval of the Pennington County Commissioners after, please reword that.
After the registration requirements or registration and all the attendant requirements are completed by the individual applicant.
Is there a second?
Second.
It's the motion on the floor and it's been seconded. This is substitute motion. Discussion, hearing none. This is on the substitute motion, Ron, that we're going to vote on that Mr. Farabee just said. All in favor indicate by saying aye on a roll call vote.
Buskerud?
No.
DeSanto?
Yes.
Farabee?
Yes.
Hadcock?
No.
LaCroy?
No. So now we're back to the original motion, which is to approve it with the changes. All in favor indicate by saying aye. Roll call vote.
Buskerud?
Yes.
DeSanto?
No.
Farabee?
No.
Hadcock?
Aye.
LaCroy?
Yes. So now that brings us to enforcement on page 18, which goes along onto 19. I see no changes on those. What I'd like to hear is a motion to approve O on 18 and page 19.
I'll make that motion.
Second.
Been moved by Busker, seconded by DeSanto to approve enforcement O on 1819. Discussion?
Have
Mr. Farabee.
substitute motion I don't know exactly where to put the language, but as I've said at the previous meeting, stop work orders should be approved by the Pennington County Board of Commissioners.
What section's that?
Oh,
You just want to add that, right?
Yep.
Is there a second to his motion?
A second for discussion, and I have a comment.
So the substitute motion was to add Pennington County Commissioners as, that they issue the stop work orders.
yes.
Okay, that was the addition that was added, second by DeSanto. Mr. DeSanto would like discussion.
From what I understand, if we leave it up to the Board of Commissioners to order the stop work order as opposed to the planning director, there is a possibility that we could set ourselves up for liability because of the time that it would take. We would have to call a special meeting to do that, and that is a big concern for me.
And your second was just for discussion.
Correct.
Okay, so we're gonna have to take a vote on it.
I want to hear what
Okay.
people have to say.
Further discussion, Ms. Hadcock?
Sure. On a stop work order, it's immediate if the planning director goes and does it. If it's us, again, another week or two, and by that time, if it's a major issue that is being a stop work order on, by that time, there could be some more, bigger issues. So I agree with, and trust the planning director, the planning department to do what it takes to either find that solution or do it in-house.
Thank you. Ron, I don't think you want any comment, do you? You just want to vote?
No, yeah, probably, but, I guess I want to hear, is there any provision for the person who gets the stop work order to come back to us and complain about it? It might be 2 weeks later, but at least, I'm not sure that they don't deserve some sort of hearing.
Sure. I would ask, is that a question for PJ or Michelle? PJ is coming up.
Not exactly sure of where it is in the ordinance, but any decision the planning director can go before the board.
They can appeal it and want.
Mr. Chair, follow up.
Mr. DeSanto.
If that is the case, and this would go hand in hand with George's concern, I believe, if that's the case, and they've ordered a stop work order, and then the Board of Commissioners overturns that stop work order, are we liable for the loss of production in between the stop work order and when we decide, you know what, that wasn't necessary, you can go back to work now? Where does that leave us?
Chairman, can we have
Ms.
PJ line out the stop work order and what that process is and how that gets done and how that gets taken care of or taken off, or what's the next step?
Usually comes in as a complaint or something that we find while we're out on a property for a routine site visit. If we verify that there is a need for a stop work order, they're issued almost immediately. I sign them, and then either I'll deliver them or our ordinance officer will deliver them on my behalf. And they'll find the responsible person on the property, and we'll usually trigger a phone call from the landowner or a contractor within 8 hours, and then we'll work with them to try and figure out what the problem is. Well, let them know that they can fix it, give them a reasonable amount of time determined by situation to fix it. Once everything we find it is in compliance, we issue a start work order.
So PJ, if it's not in compliance and you have to keep moving forward, it comes to us, right?
Depends on what the non-compliance part would be. A lot of times it would require a building permit, which is administrative,
Right.
or a conditional use permit, which then goes to the planning commission. Very rarely is it anything more than that.
Right. I guess that's my bottom line, is that
Okay.
it seems pretty simple to
Yeah.
have the planning director do it, and then if it becomes a bigger issue, it comes to us.
I think we've got plenty of information on this in order to make a decision and vote. Substitute motion on this was to make it come to the planning commission, or Board of Commissioners. Did you have one last follow-up?
I do. And it's,
Mr. Farabee?
as I've said before, this is too much power for an unelected individual from government. If this happened in the city, and I were a city resident, I can call the mayor. He's elected. We don't have a system like that in the county. closest system we have is the 5 of us. If the unelected official in the city stop work order, and it's me, I'll be on the phone with the mayor in 30 seconds. We don't have a system like that, a protection system. So my motion is to protect the citizens of Pennington County.
Thank you, Mr. Farabee.
Thank you.
We are going to take a vote on the substitute motion. All in favor indicate by saying aye in a roll call vote.
Buskerud?
No.
DeSanto?
Yes.
Farabee?
Yes.
Hadcock?
No.
LaCroy?
No. That takes us back to the original motion, which would be to approve O, which is on page 18 and 19. Roll call vote, please.
Buskerud?
Yes.
DeSanto?
No.
Farabee?
No.
Hadcock?
Aye.
LaCroy?
Aye. So that brings us to the last page, section 50C, construction permits, and section 511 in fees. From the looks of it, there was a change in transfer of mining permit prior to expiration from $250 to $1,000. And the note is a hearing is required for the transfer. The fee should be the same as the renewal application to cover the cost of notification requirements.
Move approval with the one change.
Well,
Sorry, that wouldn't be necessary because we're not doing the notice requirements under transfer anymore, because you guys had voted previously to go back to the original.
That's right.
So,
so this would be not the 1,000? It'd be the 250? Okay, so motion maker's okay with that?
With no change.
With no change? Is there a seconder?
Second.
Seconded by Buskerud. Further discussion? Hearing none. Roll call vote, please.
Buskerud?
Aye.
DeSanto?
Yes.
Farabee?
Yes.
Hadcock?
Aye.
LaCroy?
Aye. I'd like to recognize Michelle Hoffman.
Thank you. Just one minor matter. We need to add a definition for parcel,
Okay.
and that would simply be placed in alphabetical order. But the definition which I am using from the American Planners Dictionary would be any legally described piece of land designated by the owner or developer as land to be used or developed as a unit, or that has been developed as a unit.
Okay. Is there a motion to approve the definition of parcel?
So moved.
Moved by DeSanto, seconded by Buskerud. Roll call vote. Mr. Farabee would like to speak on the definition of parcel.
Where are you going to put the definition, up front or in section 320 or both?
It will be in section 320 below overburden.
You're going to put it up front also?
Just under
Yes, that's right. Definitions, George.
page 3.
Page 4.
No, because this definition will only apply to section 320. I believe that question may tie into other court matters that are not the subject of today's hearing.
Okay. So we have a motion and a second on the floor. All in favor indicate by saying aye. Roll call vote.
Buskerud?
Aye.
DeSanto?
Yes.
Farabee?
No.
Hadcock?
Aye.
LaCroy?
Aye. Now, Michelle, would it be prudent to ask for a vote on approval of the second reading with all the changes as they are? Or are we good by the way we just did it?
I would recommend making a formal motion to approve section 320 with the changes that have been made today for the second reading.
Okay. I would look for a motion
We have
to
him
approve.
still. You take care of him, Mr. Quintens?
Oh, sorry. There is still some more discussion. Thanks for reminding me. We have, I think he spoke once already from Dakota,
Mr. Quinton.
Mr. Quinton. At this point in time, before we make that motion, I think we need to take the public comment. We got a couple people there have been waiting to make a general public comment. Sorry about that. I was moving.
Didn't know if we needed to change it.
Oh, I don't know if you want to change. make a motion or?
So Chairman, Chairman too, but Michelle, did we have to change anything based on GCC's representation?
I do not believe so. If you'd like me to address that question, I'm happy to.
Okay, that'd be good.
Yeah.
Counsel for GCC represents that Section 320 in effect is rezoning this particular property. It is not. It is simply imposing regulations upon the mining industry. GCC relies on the Section 11-2-66 and 11-4-30, which simply states that the property previously owned by the cement plant was to be rezoned to conform to its use as if it was being used by a private property. This very, very clear language states just what it meant. We're simply rezoning. GCC wants to argue that because we're imposing mining regulations that somehow we're rezoning, and in fact, that it defies the intent of the statute. It doesn't. GCC then cites to SB 1, which was emergency legislation, but fails to note the fact that all of the changes proposed, including the changes to the alien ownership statute as well as corporate farming, was simply designed to allow GCC to buy the property. Prior to those amendments, it was illegal for GCC as a foreign entity to own more than 160 acres of agricultural land. That is why you have the amendment that rezones to conform to use, and that's why you have the amendment that states that any property that was owned by the cement plant was now used for non-farming purposes, and that included any successors in interest. And the last thing I would simply state is, it's interesting because in the documents that were submitted by GCC, there is a limestone study that was issued in November of 1979, and the very last, within the introduction of that study, it states, the plan was to be drawn up in accordance with present South Dakota laws and applicable local regulations. So it appears to me, even back in 1979, when the property was owned by the state of South Dakota, they acknowledged the fact that the mining operation was subject to local regulation.
Thank you, Michelle. Ms. Hadcock, do you have a follow-up?
Yes, so basically they're grandfathered in and have to follow the same rules as non-conforming.
They don't get a special exception. They basically want to be excluded from the application of Section 320, and the statutes cited do not give them some special exception from regulation. They are to be treated like anyone else in similar situation.
So basically, they're non-conforming grandfathered.
They're either non-conforming, and if they're not legal non-conforming, they'll have to apply for a new mining permit.
If they excavate outside the boundaries in which they've, okay.
Yes, and I would point out that if we were to grant them some special exception, that would probably lead to an equal protection argument by others, because under the law, all people in similar circumstances must be treated equally.
Thank you, Michelle. Mr. Farabee.
I'll repeat what I said, I believe it was last meeting, that under applicability, or somewhere, probably applicability is best, that we at least reference what the legislature did. The legislators are our legislators are our bosses, and I think we have an obligation for the future use, for future reference, to reference these statutes so that people 10 years from now say, well, wait a minute, what happened to the state cement plant? So once again, I think we ought to at least reference the statutes. You not even have to use the language, just reference them in relative to GCC Dakota Inc. Thank you.
Thank you, Mr. Farabee.
Thank you. I would first of all disagree with the equal protection argument. We're talking about a statute that's been on the books for 20 years. It was part of a bargain for sale of the South Dakota cement plant. This obviously did create a special exception. It created a special exception to allow this sale to occur. We're talking about the sale of a property for $250 million. And the preamble, the language that Ms. Hoffman did not cite, is the bolded language that said that the purpose of the act was in connection with the sale of substantially all of the assets of the South Dakota Cement Plant Commission to enable the continued operation and use of real property relating to the business of the cement plant. I mean, this was part of a bargain for exchange for $250 million. And were it not for that language to allow the plant to continue in its operation and use, the state of South Dakota would not have had a buyer for the cement plant. So this was bargain for language. It's not creating a special exception for the cement plant. It's part of a transaction that happened 20 years ago. The point in the ordinance where I believe that an exception would make sense would be under C on page 3, authority. There we're having reference to the South Dakota statutes that give you the ability to zone. Here we have a specific exemption from the zoning laws that deals specifically with the cement plant. And as such, I believe that this exemption should be referenced in this section to clarify exactly the position you're in. The concern that I have is that if GCC Dakota is considered a part of this ordinance and we're considered a non-conforming use, there's going to have to be some determination as to which language controls. And it's our position, the statute's clear. This was a bargain for sale. That's why the statute was changed. And I believe that we're inviting litigation and determining what the rationale behind this change is if we don't make it here as part of this ordinance.
Chairman.
Mrs. Hackett.
So your non-conforming use, how much have you not excavated or you plan on moving forward with in those areas? Isn't it all excavated in, and maybe you haven't seen the cement plant, but aren't you pretty much where you're going to be?
Yes, I mean, the argument that I would say is under the definition of parcel, we would be exempt. But at the same time, I would still want the added protection that's part of South Dakota statute as it relates to that property.
So are you saying if we call you non-conforming use, you wouldn't have to go through item G because you would be exempt?
Correct.
Like
I think if
else.
this, I do believe if the requested language is included, we wouldn't be considered non-conforming use because we would fall within that exemption. That relates only to the property that was acquired by GCC Dakota from the state of South Dakota. If we acquired more property, that then would potentially come in under the rest of this language. I'm only speaking of the property that was acquired from the state.
Follow-up, Ms. Hadcock.
I have a motion.
I have a,
She's not done with her follow-up.
I'm understanding what you're saying. So state overrules county unless we have it in there. And if they're grandfathered in, aren't they grandfathered in as the same use as what through the state would be a grandfathered in use as well? Meaning their intent and their sale and their 11-2-66, isn't that all grandfathered in then? Based on nonconformity?
The exemption that I'm relying on under 11-266 is that because they had to be rezoned for that specific purpose under that statute, it still controls, and that's where they remain today.
And as much as I don't want to agree with you, Quentin, I think it makes sense also because it was done in 1979 and a lot of our rules were 94 and now 2000, whatever. And not that I'd want that in one sense, but the other, they are where they are and I don't see them expanding out of that boundary. And if they do expand or open more companies, don't they have to follow those rules, Michelle? If it's not that specific parcel?
I think the problem is we are really twisting the language of a statute. Statutory construction is the language that's used. The clear language states that the property will be rezoned to conform to its use as if a private citizen or entity owned the property. It's only rezoning to conform to the use. Nowhere in that clear language does it say that GCC is exempt from regulation in the mining industry. Also, again, you have to go back to the other changes within SB1. Again, the changes solely were to allow GCC to own the property. And certainly their purpose was to continue operation, but that doesn't mean for time immemorial that they, for the rest of time, that they're not subject to regulation. You have to look at the intent of the statute. The intent of the statutes were solely to facilitate the purchase by GCC, not to allow them to be exempt from regulation. And I think putting the reference to the statutes in would be a mistake. I think it muddies the water, and, you know, the statutes really are not applicable to what we're doing here. When we talk about state trumps local, the statutes are not dealing with our local regulation. They were just solely to facilitate the sale, period.
Thank you, Michelle. Mr. Farabee said he has a motion.
Paragraph C, page 3, after the last period, add a note referencing SDCL 11-2-66 and SDCL 11-4-30 relative to GCC Dakota Inc.
Is there a second?
Second.
Seconded by Hadcock. Further discussion?
Yes,
After each
Mr.
of-
Chair.
Mr. Farabee.
Couple of comments. I understand what Ms. Hoffman is saying. But to me, implicit in these statutes is the notion that that private concern, whomever they might be, can continue in the same fashion the state of South Dakota operated under. So implicit that they took on that same privilege or lack of privileges, whichever you want to consider, and I'm familiar of a time or two that, at least one time, I've understand that the state basically told Rapid City and Pennington County to get lost.
You did.
In that vein, you know, it says 11-4-30. That's a municipal ordinance. Our ordinance, and I know some people disagree, but Pennington County does not have jurisdiction over a municipality. Thank you.
Thank you, George. Ron, do you have any comments on this?
Well, yes, I do. I don't think we need to reference anything about GCC. I don't think that, I agree with Michelle that it's immaterial. And the statutes speak for themselves. And if they want to sue us, I guess we've been sued before.
Thanks, Ron. Mr. DeSanto, do you have any comment? I don't have no comment except for I think I agree with Michelle. So I think what we'll do is we'll take roll call vote, please.
Buskerud,
No.
DeSanto,
Yes.
Farabee,
Yes.
Hadcock,
Aye.
LaCroy,
No.
3-2.
So motion passes. Now I think we have a time for some public comment. We're going to do the 3-minute thing again, and we're going to go with people that haven't spoken yet.
First.
So, ma'am, she's been sitting here waiting for.
Madakia pila and petukio hila chante washtena petchus papa. That's how we mea. Washichu chajaki be porberry matchup. I just want to greet all of my relatives today with a warm handshake. My Lakota name is White Buffalo Calf Woman. I come from the Oglala Lakota Oyate, which you guys know as the Oglala Sioux tribe. I have a deep connection with the Black Hills, and I stand before you as a common person. I don't represent any leadership within my tribe, but I am a mother, and I am a daughter and granddaughter of great people who have prayed there for many years. I come before you today to read a letter written by some elders within my tribe. The white, who are educated and civilized, swindled me, and I am not hard to swindle because I do not know how to read and write. The white man has got the gold out of the land which belonged to the red man. They made us many promises, more than I can remember, but they kept only one. They promised to take our land, and they did. These are the words spoken by Chief Red Cloud. Red Cloud's son, Jack, stated before a 1911 treaty meeting. I told the commissioner, there are people interested who are watching it beside me. Crazy Horse on the north side and Sitting Bull on the east side. So the commissioner asked me to take out tobacco to the various tribes that are interested and to ask them to come to Red Cloud Agency in Nebraska in the fall. I went, but very few answered the summons. Then it was proposed that we lease the Black Hills for 7 generations for 1/2 of the mineral that is found. And I concurred in the same, and I signed my name. June 1920, Congress enacted a jurisdictional act permitting the Sioux Indians to submit to the Court of Claims all claims of whatsoever nature which the Sioux tribe of Indians may have against the United States, and if any claim or claims be submitted to the said court, they shall settle the rights therein, both legal and equitable. Since the Indians were, and still are, wards of the government, all contracts must be approved by the Secretary of Interior. This office then, held by Lindsey Garrison, urging the Indians to employ Judge Charles Evan Hughes firm.
We have a 3-minute time limit. So could you finish your?
Could you extend it a couple minutes?
Mr.
Please?
Hopkins has
Ms.
given her his time.
Mr. Hopkins is giving you, okay. Okay.
Thank you.
You've got another 3 minutes, ma'am.
One of the firm's partners, A.L. Richards, was assigned to the case. His conclusions were, in substance, that the rights of the Indians in all the vast territories of the Great Sioux Reservation were merely hunting rights, and that any recovery would be limited to the value of jackrabbits, buffalo, etc., of which the Indians had been deprived. Furthermore, Richards felt that the jurisdictional act provided for the government counterclaims against the Indians that would completely wipe out any damages they might establish. Judge Charles Evan Hughes served as Associate Judge of the Supreme Court of the United States, May 2nd, 1910 to June 16, 1916. He also served as the 11th Chief Judge of the United States from February 13th, 1930 to June 30th, 1941, having progressive viewpoints. The Great Sioux Nation never had a chance in justice hiring Judge Hughes' law firm. The second attorney to take the Sioux claims was Ralph Case, stating, the chiefs and headsmen of the Sioux Tribe Council in 1875 wanted royalty and stumpage and the fair value of farming and hunting lands. Therefore, we will introduce our evidence as to the amount of gold extracted and timber out, and we will establish by evidence what is a fair and reasonable royalty on gold and a fair and reasonable stumpage rate for the time cut over the many years. In 1920, the Mineral Leasing Act passed legislation giving 37.5% of bonuses, leases, and royalties revenue of federal lands. It would have been nice to have a voice in Congress. Just maybe we would have received 12.5% to grow the reservation homelands as growth was within the state using the revenue. In 1976, under the Federal Land Policy and Management Act, gave the states a full half of all revenue bonuses, leases, and royalties generated on federal land. Native Nation only received 4% of the Treasury full half. At the Western Attorney General's 2013 meeting, a letter written states, the revenues owed to the mineral producing states under the MLA are not a gift, a handout, or an entitlement, but rather are the result of a compromise reached in 1920. That compensation is due to the states for mineral development within their boundaries. We have a treaty that includes a land base that was never honored by the United States government.
Time.
How much more you got left?
About 10 sentences.
Just go ahead.
I'll finish it.
Go ahead.
Okay.
Our chiefs and headsmen were not greedy. They was willing to negotiate half, not knowing states were to be formed in our treaty territory. H.R. Bill 2661 and Senate Bill 1267 are identical, entered on May 25, 2017. State Mineral Revenue Protection Act. A bill to amend the Mineral Leasing Act to require the Secretary of Interior to convey to a state all right, title, and interest in, and to percentage of the amount of royalties and other amount required to be paid to the state under the act, with respect to the public land and deposits in the state and for their purposes. Tom Udall is the Vice Chair to the Senate of Indian Affairs, is also co-sponsor to State Bill 1267. Senator John Barrasso is a member of the Senate of Indian Affairs, also co-sponsored the State Senate Bill. After hearing a brief history of how the cards have always been stacked against the Dakota Sioux Nation of Indians to our natural lands and wealth, are you willing to sit down with the tribal leaders to negotiate before the act of abolition to the Hisapa, which is the Black Hills, is your final decision? And that was from our elders.
Could you make a cop, or give that to Holly, and she can make copies to give to each commissioner so we could have that to reference to?
Yes, and just before I leave, I just want to say that this meeting really blew my mind because I'm an educated woman, but I'm an educated woman in education. And I always pray in the Black Hills, and I always take our children and our young people up there to pray, and we follow our ancient teachings. And I never knew all these processes, and I never knew the impact that it was having on the future of our tribe.
Thank you for coming. And thank you for the kind words and learning the process and taking that time. Any further public comment?
James wanted to speak.
Hold on, 3 minutes. And James raised his hand before you did, so, or Jim James?
Jimmy James.
Jim Dean, Dakota Stone.
3 minutes.
I have a $5,000 question.
Why did we know that?
Our slate mines are considered by the Forest Service common variety, and we have to pay for everything we take. We are not considered a mineral on the Forest Service side of it. So I would appreciate a motion to move common variety purchased from the Forest Service into the out of the mineral part of it to reduce our cost to 25 instead of 5,000, and that we would fall under the 320 at this time. Thank you.
Please repeat that one more time, sorry.
Pardon me.
You're wanting what moved?
Common variety.
I would like to have a motion that if you, we are mining under common variety under the Forest Service, which is not considered a mineral. We pay $6 to $10 per ton for every ton material we move off the forest. And we are definitely not considered a mineral miner in the forest.
Okay, thank you. Is that something we can address later on?
This is the second reading. If they're going to address it, you probably
Well-
address it then.
He's talking section 511 fees, right?
F, conditional use.
Yeah. Miss Nancy, I recognize Miss Nancy. 3 minutes, please.
Nancy Hilding, Prairie Hills Audubon Society. I'm going to be talking really quick here. On page 13 in G9, you have the section on roads. G is a part of the pre-existing uses, the grandfathered in one. I think you should take that clause about roads and it's just giving the authority to the Federal Highway Administration or whoever owns the road. You should have a discretionary clause in there allowing Pennington County to consider how the impacts to the county roads is in the best interest or not of the state, of the county. I want the county to, not just the highway department, to have a say in the road thing. Okay, so I also want to talk on section F, 3, which is called drainage and erosion control permits. Really, that's mostly about water quality, not just drainage and erosion. I suggest that A and C be moved into G, and that B stay in F. Why? Because this is about water quality protection, and G applies to the grandfathered in stuff, F doesn't, and you need that in G where it applies to the grandfathered in stuff. All right, okay, so then I'm going to complain about the complaint section and the renewals and the grandfathered in stuff. You got rid of the neighbors who have a concern being able to request a hearing on renewal. I object to that. But now you have this complaint section, and as far as I can see, there's no transparency in the complaint section where the public gets, complains, but, you're after that, it's a discussion between the mining company and the planning director, and the public who complained is not involved. There's no transparency. There's no hearing. There's no ability for the public to get feedback on their complaint. And so also the complaint process appears to be relative to renewals, but I don't see the complaint process being in relationship to the grandfathered in ones. So the 194 ones that are out there, if you have a problem with one of those and you complain to the planning director, is your complaint going to be considered at the grandfathered in people being reconsidered? And there's some clause in there saying about you're not about it being in the best interest of the public welfare of the county to go forward with the grandfathered in one. Because you have that clause in there saying somewhere it's in the grandfathered in thing that 1, 2, 3, the third thing is that it's not inconsistent with the health and well-being. There's no entity that's making that decision about whether it's consistent with the health and well-being. I mean,
Thank you, Ms.
you
Nancy.
have that qualifying on getting the permit, but you have no one deciding whether that is met.
Thank you, Nancy. Clarification from Michelle.
Michelle Hoffman, State's Attorney's Office. I really need to bring this to the Commissioner's attention because I don't think they understand the implications of their vote to exclude GCC. What you've done is you've excluded GC from the entirety of this document. We will have no ability to regulate. We will not be able to even enforce subsection G concerning operations because what you've done, again, is excluded them completely from section 320. And again, I would come back to the fact that the statutes did not exempt them from regulation. You have just exempted them from regulation under 320. I'd also beg to differ on the fact that we aren't creating a legal challenge on equal protection. The argument presented by GCC is, well, we have a statute, but the statute does not do what they're claiming. The statute does not exempt them from regulation. It just allowed them to own more than 160 acres of agricultural land and change the rezoning. So again, it's the board's decision. I respect the board's decision, but I just want to bring that to attention. You've now exempted them completely from section 320.
Thanks, Michelle.
Chair,
Mr. Farabee.
Totally disagree. My motion was in parentheses, after the period on section C,
Speak into the microphone, please.
is to add SDCL and SDCL whatever, it was GCC Dakota Inc., just as a reference. Totally disagree with your interpretation of that motion that we made and passed.
Ms.
That
Massa.
could be the case. I'd like clarification of the motion then, and if we're just referencing the statute, I'm not sure what the purpose of referencing the statute is, other than to create an argument as with regard to exempting GCC.
Mr. Fairby, is that what your intent was?
My comments at the time, and I'll repeat them, were that's for 10 years from now, posterity purposes. Somebody said, wait a minute, what about that cement plant out there? Well, it's right here in the ordinance. You don't got to go looking through all the codified law to find this thing. That was what my intent was, to reference those statutes for the future. You and I, we know it now, but 5 years from now, 10 years, memories fade.
Okay,
So it's in statute. That's what it was for. Thank you.
okay.
Could we that's fine. With all due respect, Commissioner Farabee, but I'd like to clarify, in fact, what the motion was that's passed. And again, if we're just referencing the statutes, those statutes are still there, and they're going to be there for posterity because they are recorded under the South Dakota Legislative website.
Okay, next I'm going to go to Mr. DeSanto.
As the seconder, that's how I understood it also, that it was just a reference.
Just a reference of what the state done. It's
So
not,
that in the future, they wouldn't, like George said, have to go through all the codified laws to find where we determined what we were determining.
so Michelle, I guess what I'm hearing, it was just a reference. It wasn't to exclude them from anything. It was just to have it in the ordinance as a reference of what the state had done.
And if we need to make language.
Mr. Chair, if I
I'm going to, just let me get this clarified. Kara?
Yeah, George said he'd repeat it for us.
Okay.
So I can get it correct too.
Now, if it's not exactly the way on tape.
Well, I can listen to it on tape too and make sure it's
But
right.
in parentheses, after the last period on subparagraph C, is add reference to SDCL 11-2-66 and SDCL 11-4-30 relative to GCC Dakota Incorporated, close parentheses. It's a note, put those, and that's not exactly the way I said it before, but excuse me, I don't,
Nope,
I
I'll
don't have
listen
that
to
kind of
it.
memory. But
Chairman?
no,
Just a second, these.
10 years from now, 5 years from now, somebody, if whoever's in power then and whoever's in authority then wants to have a lawsuit, argue about it, and at least it's there for them to see in this ordinance. They don't have to go looking through a stack of code books this thick to find where the hell that statute is. Those two statutes. Thank you.
So, Mr. Farabee, for clarification, your intent was never to exclude them from any permitting or regulation.
No, you can interpret any, here's the statute, you can interpret it any way you want to. And I've always said, and I'll say again, you ask 10 lawyers what the statute says and you get at least 11 answers.
Okay. That's
Sorry, lawyers, but that's the way it is,
that's
right?
what I wanted
That's the
to-
way you make money.
Okay, I
And
want to
Buskers
clarify.
would agree.
Ms. Hadcock.
Okay, so you put it under authority for the purpose of promoting health, safety, welfare. Board of may adopt a zoning to regulate and restrict the height number. So basically, hey, Jessica, if I put it under authority, am I basically regulating 11-2-66 or Mr. Hickey, 11-4-30? What am I doing if I put it under authority? Am I saying that we have to reference it, and then once we reference it, it's as good as saying that their authority over us is based on 11-2-66?
I'm going to agree with Mr. Farabee that as it's inserted, it's subject to the interpretation of whoever is reading it, and so it depends on who my client is on what I'm going to argue on what it means. So,
No.
Well, that's what I'm saying either way. So it can go Michelle's way or it could go GCC, just depending on the issue, and that's what I'm getting out of it.
yes.
So either way, I think we're going to have an issue. So George is right. So if we put the reference in there, at least we know what we're references for the future in case GCC comes up and argues otherwise.
Michelle.
Mr. Chairman,
Mr. Buskirk.
I'm going to make a motion to approve the second reading of this ordinance with the various changes and amendments that have been made.
Second.
We've got to have a very formal motion. It
For
has to be-
discussion.
Actually needs to be approval of second reading and the adoption of 0A17-02.
I think that was Ron's motion.
Yep, that's what I heard.
Yeah, I think I must have cut out when I said
Yeah.
that.
And it was seconded by DeSanto. Further discussion? Hearing none, all in favor indicate by saying aye.
Aye.
All opposed, oh, roll call vote.
But before we do that, I'm a real stickler on, we should be voting on a finished document, and I know there's a time deadline and all that. Promises are made that the words, everything gets changed the way we wanted them changed. And that's a very dangerous road to go down. I am going to abstain on voting until I see the finished product.
Thank you, Mr. Farabee.
Thank you.
Roll call vote, please.
Buskerud,
Aye.
DeSanto,
Yes.
Farabee, you're
Abstain.
abstaining. Hadcock,
Aye.
LaCroy.
Aye, motion passes. Thank you, folks, for all your hard work and time, and I want to take the moment to thank Michelle and Jerry and Holly and all you guys for all the hard work you've done in the last couple of weeks.
Yes, thank you, staff. Couldn't have done it without you.
Yes.
And for
Motion
the
to
food by
adjourn.
Joan.
Oh, yeah.
Motion to
Buskerud.
adjourn, seconded by Hadcock.
Yep.
Roll call vote to adjourn.
Buskerud,
Yeah.
Buskerud,
Aye.
DeSanto,
Yes.
Farabee,
Yes.
Hadcock,
Aye.
LaCroy.
Aye, we're adjourned.